was the trial court did, the trial court, my lord, appreciated my entire case and said, in one of the previous sale deeds, the measurement is less by 3 feet. Therefore, there is no proper title, my lord. The interim order was refused. At the same time, my lord, the respondent also had filed, my lord, a suit on my property against me. They, my lord, wouldn't get an interim order. What they would do is, moment, my lord, they were observing my case. The moment the interim order was refused to me, they would withdraw, my lord, their suit, in which, my lord, I had appeared and I was, my lord, implicated as a party respondent. They would withdraw that suit. Overnight, my lord, would go and occupy the property. Put up, my lord, that, my lord, rapid construction, my lord, the services should be engaged, my lord, for some state, my lord, activities. Otherwise, my lord, I have never seen, my lord, such rapid construction overnight, my lord, first floor. My lord, within next 3 days, my lord, another floor. My lord, thus progress is seen from the photographs which we have placed, my lord, periodically. Then we came before this honorable court, my lord, seeking an order. They were, my lord, in caveat, and my lord, they appeared and they opposed. On that day, my lord, my lord, they showed it to the honorable court that this is what they are trying to do. Their case is that they are the owners of property number 155. But I am nowhere concerned with 155. On my property, they would come and write, my lord, 155, my lord, by using a paint and brush. Now, my lord, the last development, my lord, which I would now, my lord, just pass on, is that because, my lord, we have been constantly saying that my property is 206, your property is 155, our property is nowhere matched. Therefore, there has to be an order. What they would do, my lords, may kindly see, this is what they would do. My lord, day before yesterday. At the time when we came to court, my lord, there was only brick and mortar. Now, my lord, this is the level of the building.
So what is the order of the court?
The order of the court, my lord, is refusing an injunction. This honorable court, my lord, stopped them from going ahead with any
Where is that? Where is that?
My lord, order dated 5/6/2024.
Yes. Yes.
My lord, therefore, this honorable court, my lord, took note of the contempt, referred the matter to the honorable registrar judicial to record the evidence. Evidence was recorded. They were cross-examined. All the photographs were shown periodically. And, my lord, they admitted, yes, they were continuing with the construction. The only, my lord, answer was that, no, we were not doing a construction. My lord, the photograph shows it all, whether they were doing the construction or not. The only line of, my lord, defense of the lady who was examined was that, no, we were just putting up some grills.
He would, however, submit by producing copy of photograph that 1-bedroom single floor house is already constructed.
Yes.
In suit property, and the same status would be maintained till disposal of the suit, and further construction would be subject to final outcome of the appeal without claiming any till disposal of the suit.
My lords, may kindly see, my lord, page number 102, my lord, the photographs as on the day when we approached the court. Page number 102 of, my lord, the appeal memo.
On 5/6, they have also filed one.
Page number 102.
What is the new construction that has come up now according to?
My lord should kindly compare, my lord, 102, page number 102
Of the appeal memo.
of the appeal memo and the photographs which I have now placed on, and, my lord, the periodical pictures which I have placed.
Evidence.
My lord, this was what they were doing. As my lord should kindly see on page number 102 and 104. This was what the status. And, my lord, they confirmed it because they also produced a couple of photographs showing the same status, which is not in dispute. And kindly see, my lord, in the teeth of the honorable court's order, this is what they do.
Yes, we'll ask them.
So grateful. And, my lord, one last submission. If your lordships could kindly see, my lord, for a moment, my lord, page number 150, 102. My lord, on that day, they came and wrote on my property number 155. On my property number 155, my lord. Kindly, my lord, see today's pictures, my lord, which I passed on, what they would do. This is nothing but, my lord, playing fraud right under the nose of the honorable court. Kindly see, my lord, the second picture of which I have passed on today. To overcome, my lord, my defense, they would now write old 155, new 206.
That was never the difference.
It was never there. It was never the difference.
Yes. Yes, Mr. Srinivas.
Lord, the evidence has been laid. May I just draw your lordship's kind attention
What are
to
the evidence?
the photographs filed along with the evidence affidavit by the respondent, by the petitioner, by the appellant, Lord, on kindly note the date, page, photograph bearing annexure B6
You're referring to which are filed along with the writ petition.
along with the evidence affidavit they have filed.
Before
Before the
judicial
Which one?
No, my lord, before the Honorable Registrar Judicial, they
Evidence
place certain
affidavit.
photographs.
Evidence affidavit filed before
They
the.
themselves place certain photographs. If my lord should kindly have, my lord, there. It was the number.
Application.
That's the one I want. Yes.
And even our application, my lord, we have produced
13.
on 13/6/2024, my lord, certain photographs are produced.
Lord,
You're referring to what are the
page
photographs?
8, page
Please
8.
show that.
Please,
You're referring to some photographs. What are they?
the page 8 of the photograph filed along with the evidence affidavit before the registration
ಇದನ್ನೇ ಮಾಡ್ಬೋದು.
Evidence affidavit, yes.
evidence.
Oh,
Page 8,
page number 8, yes.
page number 8. Lords may kindly see the down photograph showing the date June 10th,
Hmm.
2024. June 10th.
No, I
So
don't
this
think-
grill was,
Granted on
Uh,
6.
grill was put,
Anand,
Exhibit P8.
exhibit P8.
This P12, P11,
P8.
P8. B8 or P8.
Something
Page
else, I
8
think.
of that photograph. The evidence affidavit records. June 10th,
There is no P8 in this.
annexure B8, down below that PW1 within brackets.
No
exhibit
P8 in this.
B, my lord. I think my learned friend is saying B, my lord. These are the
P8,
pictures.
P8.
These are the pictures which we produced to show that
Yes, ma'am.
subsequent to the interim.
No, you have placed it before the,
Registrar
that
Judicial.
is what I'm
What,
looking at.
what I wanted
This
to
is how
submit is,
it is.
Lord,
Oh, no, my lord, that was
That
what,
is-
my lord, one of the photographs which was confronted to her. May I just, my lord, there is an application, my lord, which is dated 13/6/2024. There is an application. my lord,
Yes.
13/6
Yes.
in that.
see, on 13/6, we filed the effort, we have given the, we have taken the undertaking,
Not on
stating that we will not put further construction. My lord, what we have done is to put up the water tank, some brickwork was done. That is the main
So
complaint.
please come to this page number 4
Page
of,
number,
of those photographs,
page number 4.
4. That is photographs dated 11/6/24.
June 6th.
Page number
Page
4, my lord.
8.
My lord, I will just clarify. On page number 4, as my lord sees, these two are the pictures which were given by them on the day when the interim order was. passed
Yes.
in this honor.
Yes.
Now from
June
there,
8, page number 6, June 8, 2024. By that time, this brickwork for putting up water tank was done. Subsequently, on June 9th, your lordship could see this grill work has been done. On 13/6, we have given the undertaking. By that time, this was complete.
5/6. The interim order is 5/6.
Lord, we have filed the undertaking before this honorable court on 13/6. Undertaking that we will not put
Give
up
that order.
construction.
give that.
Lord,
Order
13/6,
is passed on 5/6.
yes. Order is passed on 5/6.
So that's the day the court has,
Lord, that is not the further construction. It is only the for the safety of, for safety.
when once the
grill was
court
put.
says status quo, it is by all means status quo. Not that you will finish the unfinished
That is-
work. That's
that-
not the
That's
thing.
miscommunicate by due to some miscommunication.
Then how is he going to say
Lord,
that?
the further construction we have not made.
It is not
The
about, it is
construction
not about
was-
further
The
construction.
construction was completed by the
When the
time.
court passed an
only-
order, there should have been a standstill.
And yes,
Yes, doctor. So
we have
what
to
of-
apologize for, so far as that is concerned, my lord, undoubtedly.
So that's why we'll grant injunction and let the suit go on.
My lord, further construction, we are not going to put, let the suit go on.
Yes.
We will not put up further construction. Whatever construction is made, that is,
That is one aspect.
yes,
So whatever violation that has been committed till now,
yes.
what is your, what should be the course of action according to you?
It's a-
Because they can't,
I
litigants
agree.
can't be
I
permitted
fully-
to take the
I-
orders for granted like
I
this.
fully agree with your lordship.
Then
Lord.
there is no sanctity for the order at all.
Lord, according to my instructions, that client was away and he miscommunication, the person was
Court
authorized to
orders can't
construct.
be missed.
Yes,
When something is in their favor, there won't be no miscommunication.
yeah, I understand. I understand.
We'll
But
impose,
further
we'll
further
impose costs. We'll impose costs for this. And then we'll grant, considering your undertaking and also these photographs
yes,
that are filed, that are dated,
it will not change further,
11/8,
further changes in the
2024.
construction.
there shall be a status quo as obtained on, as per
Yes,
these photographs.
let there be an order to that.
Yes, please come.
And my lord, they are now occupying the property. This is what my lord.
That's-
they are doing. They
that's
are
in our
occupying the
possession.
Entire endeavor.
No,
The
that is
entire
in our
endeavor,
possession,
and that, my lord,
because
I just make
there
this
was
observation.
no interim order before the trial court, as
One
long
fact-
as we
One
completed
minute,
the
one
construction.
minute. One fact is clear, they are making the construction, that is in their possession. No, their possession, now we cannot, now we can only say not to maintain status quo, not to create any third party rights or
Yes.
whatsoever.
Yes,
No, when something is there, let them use it. No, they will not claim any
I
equities.
take it to your lordship discretion
Yes.
on that. I love
Please,
it.
that's,
My lord, there
that's
is
fine.
specific application, my lord, which is filed, not seeking action of contempt against it. I just want to say.
Lord,
We trial
your
court
lordship
already-
said indicating that the
Yes.
cost may be imposed. Your lordship at liberty, because that is wrong. I also admit,
Yes,
I
yes.
cannot.
That's on.
Choose on.
The present appeal is filed, agreed with the orders. Passed in I number 1 in OS number 250 of 2024 dated 15th March 2024. Whereby the trial court had rejected the application filed by the appellant plaintiff seeking injunction. The appellant herein had filed OS number 250 of 2024. Not happening. You should enable that. No, it will type from provided I dictate it. The the suit is voice number 250 of 2024 is filed. Call them, no? Call the computer. Seeking injunction in respect of, where is the plaint?
Plain
Kindly
is at
find.
page 32, annexure B.
Seeking injunction, restraining the defendant in any way interfering with the plaintiff's peaceful position and enjoyment of the suit scheduled property. It is the case of the plaintiff that is an absolute owner and possessor of an immovable property bearing vacant site number 206 formed in portion of old survey number 83, new converted survey number 83/1B, but conversion order dated 21/1996, issued by the Special Deputy Commissioner, Bangalore North South Taluk, situated at Maltahalli Village, Yeshwantpura Hobli, Bangalore North Taluk, measuring east to west 60 feet and north to south 40 feet, which comes under the administrative control of Bruhat Bangalore Mahanagar Palika. He has purchased the said property by way of a registered sale deed dated 10/4/2019. The vendor of the plaintiff has acquired the suit property by virtue of a registered gift deed dated 2/2/2015, executed by his brother, which is a registered gift deed. And there, the vendor, the said Ramesh has acquired the property by way of a registered sale deed dated 2/2/2004. And his vendor had purchased the property by 24, as per the vendor, as per the conversion orders passed by Special Deputy Commissioner Bangalore, and also conversion sanction dated 24/7/1995 issued by the Tehsildar. They have they have acquired the land by way of registered sale deeds. It's a case of the plaintiff that since 2004 till now, the property, he has filed the tax receipts. According to them, they are in peaceful possession and enjoyment of the property, right from the vendors till the plaintiff. It is a case of the defendant that on 2/1/2024 and 3/1/2024, the defendant has come to the suit schedule property and attempted to interfere with the plaintiff's peaceful possession. And the plaintiff, in this regard, a police complaint is also given. In those circumstances, the plaintiff had come to the court seeking the relief of injunction, restraining the defendant. The defendant had filed his written statement. It is a case of the defendant that he is the absolute owner of the property, and he is in peaceful possession and enjoyment of the immovable property.
Hmm?
So the defendant is that.
That's may.
Right, bearing number 155.
The defendant is the defendant's properties, item,
Site
property
number-
site number
150.
That's what I'm recording that he is in peaceful possession and enjoyment of the property bearing site number 155, Kata number 83/1B/155, formed in old survey number 83, new survey number 83/1B, which is converted the non-agriculture residential purpose by conversion order dated 21/1996, issued by the Special Deputy Commissioner Bangalore. And they have purchased the said property by way of a sale deed dated 36/2016. And they have also stated how the vendors have acquired the property. According to the defendant, after purchasing the sub-property by way of the registered sale deed, he is in peaceful possession and enjoyment of the same. And his name is also registered in the municipal records. He has also constructed a compound wall with iron gate for the internal access, and also constructed a small sheet house with electricity connection sanctioned by the concerned authority. And he had filed the said documents before the court. On 31/7/2023, they have noticed that some strange persons continuously for 3-4 days are coming to the said site and illegally entering the in the said premises. On 2/8/2023, when the defendant has come to the place along with the laborers to clean the said site number 155, by removing the unwanted plants grown and garbage dumped in the said property. Therein, the plaintiff, with the help of some antisocial elements, trespassed into the land by claiming that he is the owner of the property. And he also refers to the police complaint. The defendant has denied the title of the plaintiff in respect to the property. According to him, the suit scheduled property, that is as on the day, the sale deed dated 2/2/2004 is executed by H.V. Ramesh. The plain scheduled property bearing number 206 was not physically existing as the original transaction of the said vacant site is dated 18/2/1999. Hence, the sale deed dated 10/4/2019 of the plaintiff is in respect of a non-existing suit scheduled property bearing number 206 is not valid. Along with the suit, an IA is filed seeking interim injunction, that is IA number 1. By way of this order impugned, the trial court had dismissed has rejected the said application filed by the plaintiff. While rejecting the said application, the trial court has observed that the plaintiff, in order to establish the prima facie case, has produced a letter written by the plaintiff to the ICICI Bank Limited, where he has mentioned about the sale deed, encumbrance certificate, gift deed, Form B, and tax paid receipts, which are in the custody of ICICI Bank. And he has produced the registered sale deed. And also, the court has discussed the measurements with regard to the documents that are placed on behalf of the plaintiff. Then the court comes to the conclusion that in the sale deed dated 2/6/2004, as well in the gift deed dated 2/2/2015, the extent of the site bearing number 206 was mentioned as east-west 60 feet and north-south 40 feet. But in the sale deed standing in the name of the plaintiff, the extent is mentioned as 60 feet into 37 feet, which is contrary to the previous title deed. And there is no explanation on the part of the plaintiff with regard to the said material discrepancy appearing in the extent of the suit property. And the court considered the case of the defendant, wherein it is stated that they have been in possession of the property right from 30/6/2016. And also their case that the sale deed is executed in respect of a non-existing property. But further, that some structures are existing in the suit scheduled property. And considering all this, the court felt that there is no prima facie case in favor of the plaintiff and prima facie case balance of convenience and not in favor of the plaintiff, and accordingly rejected the application. Agreed thereby, the present appeal is filed. When the appeal has come up before this court, and by the time the defendant has already filed a caveat before this court. And this court on 5/6/2024 has passed the following order. This order extract as it is. It is a case of the plaintiff that after the orders are passed by this court, the defendant had made further constructions and clearly violated the orders passed by this court. Then they have filed I number 3 of 2024 to take action against the respondent for violating the orders of this court. Then by order dated 18/6/2024, Registrar is directed to, the Registrar Judicial is directed to record evidence within 4 weeks, and parties were directed to appear before the registrar. There is a report of the registrar. Hmm.
ಕೊಟ್ಟಿದ್ಯಾ ರಿಜಿಸ್ಟರ್ ಏನಂತ ಬರೆದಿದ್ದಾರೆ?
accessibility.
There is a report. Yes, sir. Hmm? There is a report, and that it must be. Hmm? Hmm. Okay. The RJ has submitted a, Registrar Judicial has submitted a report before this court. This court has perused the photographs that are filed before filing of the suit in this court by the respondent dated 11/6/2024.
These pictures were filed on 5/6, my lord, on the very day.
Even 11/6 also, if you
Yes,
see,
periodically.
13
Uh,
months.
the interim order is granted on 5/6/2024. This court has perused the photographs filed on 11/6/2024 and the present photographs, which clearly shows that after an order of status quo is passed by this court, still the respondent has, the respondent defendant had made further constructions. On this, the learned senior counsel appearing for the respondent submits that there was a communication gap, and they have only completed they have only cleared, what is that?
Construction for putting up syntax tank.
They have completed the
And degree.
construction.
For safety.
Putting up
That's all.
for putting up the syntax tank and no
Safety
further
clear.
construction has been made. As they've already given an undertaking, they will not make any further construction. It is submitted that there is no willful violation of the orders of the court, but it's only a communication gap between the defendant, it is submitted that as on the time, the defendant was not in town. And as in view of the communication gap, this little further construction had taken place as submitted by him, that it is putting up of a syntax tank. Then a senior counsel appearing for the appellant plaintiff submits that the action of the defendant is in clear violation of the orders of the court, and the application that is filed by them, that's I number 3, has to be allowed, and he should be punished for the violation of the orders of the court. He submits that once an order is passed, granting an order of a status quo, and also when an undertaking is filed before the court, the defendant ought not to have made the construction. It shows that that it's a blatant violation of the orders of the court, and willfully the orders of the court are flouted. Further, on the merits of the matter, Learned Senior Counsel submits that he has placed before the court, the plaintiff had placed before the court all the documents to show that from a very long time, the plaintiff and the vendors of the plaintiff's vendors have been in possession of the property, And just because in one of the sale deeds, there is because that some, the measurement is differing from in one sale deed, on that ground, the court had refused to grant injunction, which is not, which is in clear violation of, which is contrary to the purport of the said provision, and unless this injunction is granted, it would cause irreparable loss and hardship to the plaintiff. All these aspects were not considered. He submits that earlier the defendant has filed a suit, and in that suit, he obtained injunction.
No,
No.
the injunction was refused
Uh,
because my lord, their injunction was refused,
uh,
and by then
Your
they would have,
injunction,
my injunction was refused, they would withdraw
initially a
their suit.
suit is filed, and in that, when the court had refused the injunction, and at the same time, in the suit that is filed by the plaintiff, the appellant herein, when the injunction was not granted, they have cleverly withdrawn the said suit filed by them. It is submitted that all this action of the defendant shows that he's playing fraud on the court, he's violating the orders of the court. And also, it also shows the conduct of the defendant. Next para. Having heard the senior counsels on either side, peruse the material on record. This court had perused the order dated 5/4,
By 6.
5/6/2024, passed by a coordinate bench of this court. And the photographs that are filed, which are dated 11/6/2024, which are filed by the defendant himself. Now, this court has also perused the photographs, which shows the present stage of the construction or the status of the said construction, which clearly shows that the defendant had violated the orders of the court.
Only
And
for the safety of,
huh?
safe. for
that
the
I'll
safe-
record, violated the orders of the court, and made a further construction. For that, the explanation or the submission of the defendant is that to safeguard his property, he has to make certain constructions. He had to install the
Only grill
tank.
has,
Huh?
only grill has been.
Grill has been installed, the grill has been installed, and also he, for
No further
the,
construction.
for the purpose of preserving the water, a tank has been installed. This submission of, on behalf of the defendant cannot be appreciated. Whatever is the necessity, when once a status quo order is passed, the defendant cannot make the construction and cannot come up with this kind of a plea before the court. If at all, for any security purpose, something has to be done. The same could have been done after obtaining the necessary permission from the court. Considering all these, all these facts and facts, this court deems it appropriate to issue an injunction restraining the defendant from making further constructions. And at the photographs that are filed, what is the date? Latest photograph.
Today they have filed the
Okay,
photograph.
my lord.
Oh, that is filed by you, I think.
Yes, my lord, we have placed.
This is dated 11/8. The
Yes.
photographs that are filed before this court are dated 11/8/2024. There shall be an injunction restraining the defendant from making any further construction whatsoever. And he shall not create any third-party rights.
And my lord, let them not claim
As far as,
equity possession.
Huh?
Let them not claim equities, my lord.
In case, that is,
But
that
they-
always
yes,
goes
yes,
without saying.
yes, that
And
has
he
to.
shall not, the defendant shall not claim equities in case the plaintiff is successful in the suit. Further, the defendants, they are at liberty
Subject
to
to the
use
result
the
of this
premises.
are at liberty to be in
Ah.
possession.
Yes, they are at liberty to use the premises
This much.
disposed of.
my lords were saying, my lord, they have to be punished for the contempt, my lord, that portion is left out.
That,
That
for that, no,
portion, my lord, is-
when it comes to, when it comes
My
to I
friend
number
is bent
three,
upon
I
In
number,
fact,
when
my
it
lord, my
comes
lord said
to,
it, my lord.
when it comes
lenient-
to,
lenient view.
when it comes to I number three,
It is a lady.
it is, when a senior counsel argued that when there is a finding of the court that there is a
lady, my lord.
violation of the orders of the court, he shall be punished for the same. Considering the facts and the submission that is made on behalf of the defendant, this court deems it appropriate to impose the cost of 30,000 on the defendant, which has to be paid to the respondent, to the plaintiff.
Let it be advocates welfare fund.
Hmm?
Let it be deposited before the bar council for advocates welfare fund.
I leave it to your lordship's discretion.
To the Advocates Association,
Welfare fund.
to the Advocates Welfare Fund.
Watch it.
Then my learned friend also being, my lord, not my lord, learned senior advocate. My learned friend, my lord, being lawyer, would take advantage of his own fault. My lord, unalike to it. Because my lord,
Because the
welfare
government-
fund goes to his
No,
benefit
the
also.
government is not contributing any amount. It is only we have to pay the amount by fixing the stamps and all.
No, because he is appearing for the respondent, then he will be also a beneficiary.
Yes, he'll be a
What he is
beneficiary.
saying.
All of us, all.
Can you just make one prayer, my lord? My lord, could the trial court be put on, my lord, certain time frames, my lord?
Which year is the suit?
Already issues.
The
framed.
suit, my lord, is of.
Already
the year.
issues
Right,
have
it's an
been
injunction
framed.
suit. My lord, we will not take any.
Which year? Which year?
The suit is, my lord, of the year
24. my lord.
24.
Present year,
24.
24.
I think last occasion when you appeared, you
In
placed
fact, my
it.
lord, I said, my lord has all the rights. My lord, the Honorable Supreme Court, my lord, does not say. It only
what will
says
happen
normally.
No. Some of the judgments with what you assist the court, sometimes it is not useful for you, but
That's the
useful
reason,
for
my
the
lord.
court to use it the other way.
Burden would be very heavy on the trial
That's the
court.
reason, my lord, I was very honest to say, the Honorable Supreme Court never said the constitutional courts have got no such power. Generally, my lord, looking at my lord. the
Because
code
it's a 2024 suit that can't be an order.
So.
Please, much.
Cell number two, Yeshubaba Mishra, a petitioner.
What has happened to you? Passover, you don't even appear? Yes, what has happened? When is why you have not even filed the IA?
Same IA, my lords, but the only.
How can there be, you ask for a custody and court will grant a maintenance, how can it be?
The challenge. Yes, we had asked for interim custody matters. The same was rejected. Instead.
Where do you get that order? Let us see.
Page number 20.
Page number? Hmm.
Interim custody was rejected.
Come to that operative portion of the order.
Page number 28 minutes. The respondent is entitled for visitation rights of the minor child so and so.
The court observes that interim monthly maintenance of 30,000 from the date of application. So a separate application is already filed. Now this order is in respect of two applications. One is for visitation and one is for maintenance. So you have filed which is not relevant. When you are questioning the maintenance, you have to file that IA. Come to the order. Then without there being an application, without any discussion, how can the court direct?
We had asked, we had sought only for interim custody. That was rejected and visitation's rights were granted on the basis that the petitioner resides in US, but he actually resides in Bangalore. Every cost type also shows that the petitioner stays in Bangalore. Following which an interim maintenance.
I think there is no such. Anyhow, in this matter, I think there is no application. Continue. No stay in this. Your salary is 3 lakhs. What's this matter? Huh? If arrears 15, no arrears. Because there is no date for that. Still you are at benefit. If it is, you have to pay 9.5 lakhs from the date of application. No, the court is only saying pay prospectively that 30,000. You have not paid anything till now. Let counsel for the petitioner submits that the court, without there being an application, had granted an amount of rupees 30,000 towards maintenance on an application filed by the father seeking visitation of the seeking visitation rights. Considering all this, there shall be a stay of all further proceedings on the condition that he shall deposit an amount of rupees 15,000 per month by 5th of every succeeding month, and and an amount of rupees 4 lakhs, part of the arrears within 4 weeks. Same, either that is not paid or this stay granted by this court stands vacated without further reference to the court. We shall serve a notice on the counsel appearing for the respondent by a memo shall be filed by 29th of August. Post this matter on 13th of September. Yes, next.
Number 3. Purti Hegde.
My lord, appear for the petitioner in petition number 622. Yesterday, my learned friend has done the argument. My lord, recollect, this is the matter wherein I came before the court challenging the order passed by the learned trial court, whereby the maintenance is increased from 70,000 to 80,000 rupees 90,000 per month. But I'm filing a compilation also some new documents which are already there.
Will not look into any new document.
Not new
What you
document.
abide before the trial court, that only you place.
Only to that extent, nothing, not in that sense, my lord. It is in the context of all the.
Did your client informed you? Did your
My
colleague inform you?
yesterday.
So now whatever order I pass, either this way or that way,
Yes, ma'am.
but cost will be imposed on both of you. That is for sure.
I'll try to
With that,
satisfy the
with
court.
that you please proceed.
I understood.
Uh,
ma'am.
Because both of you, with all your egos, just like that, you approach one after the other application, and the courts have no other work but to look at your application.
My lord, let me-
You, what is your income?
My income is more around 8 crores. My lord, let me,
8?
crores per annum.
Hmm.
My lord, let me point out whether my contention is what, my lord, especially in this case, I was not required to be burdened with 90,000 rupees per month, considering the conduct of my wife.
That we will not consider at this point of time,
My lord,
because that can only be done after a full-fledged trial, not at this point of time.
my lord, there's many circumstances which has come on record. There is a fraud played upon the trial court. Certain false statements are made on the strength of which this order came to be passed, which is glaring, my lord. You take the system for granted, with impunity go on making false allegations, and luckily evidence has started.
We are at the stage of
Yes.
interim application
I'm
for
able to
maintenance.
accept.
We'll only consider two aspects. What is the income of the husband? What is the income of the wife?
Yes.
And,
Plus, she's drawing 33 lakhs according to her as on date.
Hmm.
Even currently, she's drawing that kind of money.
Hmm.
My contention is that, my lord, just because I'm the husband, does it mean I go on paying the wife, which has been the root cause for many other difficulties in my life? We stayed only for 6 months. Just let me point out few circumstances, my lord.
You already pointed out.
No,
So
my
many
lord,
times.
from
you
the
argued
reading
this
of the
matter
order.
For me, I remember.
Yes, my lord, not only that, even what was the basis for.
What your client is not able to understand is that it is not something very unique to him. This particular saying that she is 6 months, it's not about 6 months, 1 year or 1 month. No, as long as the divorce petition is pending before the court, what is the purport of this interim maintenance and how it has to be paid.
Like,
We will not consider now, wife had willfully deserted me, she did that and this, that will
I'm
be
leaving
decided
that
in
thing
the
aside
full-fledged
for a
trial.
moment, my lord.
Yes.
Let me point out, my lord, here we are dealing with, let us see the impugned order, starting from page number 22, my lord. How the false statements have prompted the learned trial just to pass an order in her favor. Luckily, evidence has started. In the evidence, it is clearly come that she has always been employed and she's been making money. And the strength for passing of the order by the trial court is that she's not employed. She's not earning anything. Let me point out that this is serious fraud played upon the trial court.
Where is that?
Yes. So it is part of the impugned order. Page number, starting with the page number 22.
Page number?
Page number 22, that is first volume, my lord. Of my petition, my lord, 6222.
Page number?
Page, the relevant part is on page number 24. Starting of the impugned order is on page 22.
Yes.
My lord could consider about third line from the bottom on page number 24. The petitioner is earning crores of rupees. He's a chartered accountant working with Morgan Stanley Private Limited. On the other hand, she has no independent source of income to maintain herself. The petitioner is also having income from other sources. This is her contention, which is recorded by the learned trial court. My lord could consider page number 13 now,
Yes,
para
Yes.
number 16.
yes,
The above respective affidavit of assets and liability prima facie reveals that the petitioner is gainfully employed and his earnings is more than the income of the respondent. The respondent has produced later issued by Savant Foundation and submitted that she is working as NGO and not getting any benefit of consideration.
yes,
This was filed in 2022 on the strength of this is the point considered by the trial court to give the maintenance of 90,000 per month. Now it is come in the evidence, my lord, what is getting recorded as per the order of this very court. She admits that even as on date, forget about 2022, my lord, even as on date, she is employed in the very post, she is getting 33 lakhs per annum.
according to her, when she started working?
My lord, she's been working continuously, that is also part of the evidence, my lord. Even
Where-
when
where
she
is the
stayed
evidence?
with me.
Where is the evidence?
Yes, ma'am. No, it is in the new compilation which I filed today.
Page number?
Well, just before that, may I point out one more circumstance, my lord? In terms of
First of all,
the
point that.
684,
Page
684,
number?
684, my lord.
Yes,
Yes, ma'am. So this is the evidence which is going on as per the order of the Honorable Supreme Court. We come to be completed within a matter of 1 month. My lord could consider page number 684, somewhere in the middle. I started working in June 2010. I started working in data monitor company from June 2010 till June 2011. My lord, I got married in 2014.
read.
Thereafter, I started working in Google company from June to 2011 till June 2012. November 2012, I started my own company. After marriage, I was not allowed to work, hence the company had to be closed. I do not remember the date on which the company was wound up. I can check the documents and inform the court about the details. In 2015, second half of the year, I tried to start another company. After 7 or 8 months, I closed the company to focus on my marriage. The name of the product was Kid Around. I had not registered the company formally. The said product was IT related app. After closing the said company, I was consulting another company called Traco for 3 to 4 months in 2017. I do not remember exactly. I can inform the court about the exact date on the next date of hearing. I started working as a consultant in 2019 September in for a company called Sugar Box. I was asked to leave from the said company in December 2021 due to my lack of focus in the job. I was working for 6 months in 2022 at a company called Better Place. I was asked to leave from the said company in June 2022 because I was traveling frequently to Mumbai due to litigation. I started working in Pine Labs in the end of 2022 as a consultant for a group entity. I have been
Come to the application that is filed now.
yes, ma'am. But may I point out the assets and liability filed by this very same?
Please, you can go later. Please come to the IA that is filed. What did she say?
Yes, ma'am. That is the application of 125 that is was decided by the learned trial judge. I just pointed, ma'am.
It's in the old.
Lord, it is in the first state of compilation. My lord, starting from page number 258,
Yes. 250?
258, my lord.
What did she say?
Well, this is the copy of the petition what she had filed in the family court, on the strength of which she got this order. But throughout, it's running into a number of pages. She contends that I am not employed. And that was the contention when the application got decided.
When is this application filed?
No, this was filed in the year, originally filed in 2017, but decide 2018, my lord,
12th February 2018.
18, my lord. I filed the original case in 2017 in Bombay. And this application came to be decided recently. I give the exact date also, my lord. What is the date of impugned? Page number 22 is the date impugned order.
Why all these facts were not stated in the petition that is filed by you?
On 18, my lord.
There are facts on 18 also.
Yes.
That you are working?
Working, it's a consultancy, it's not for anything.
No, you have to tell the court.
For gain, my lord.
No, no.
That was, I have. pleaded
Let
with
us
the
look at
argument.
it.
And even 273 of my volume of the assets and liabilities, my lord, I have clearly stated my assets and liabilities, 16 lakh rupees as on 21-22, my lord. My assets and liabilities.
No. It's your case in the affidavit that's filed, is you're not working anywhere. You never, after the marriage, you stopped.
Yes.
Because they were, no, and what evidence you have given, interpretation number 685,
These are all
is contrary to
consultancy.
what it is.
This is entirely, we have been thrown out. Instead of throwing out, they have diplomatically said, you go out of the company, you are not.
No, that are relevant factors to be stated before the court and to also place before the court what was, in which company you were working, for how long you worked, what is the income.
One company, what they have brought before the argument.
No, that how the court will know unless until you tell the court. You have to, you should have been fair to the court. And when you take advantage of the judgment of,
I have placed all my income tax before the
No.
family court.
it is not for the court to read. You should also tell the court what you want, what you have to.
The family court has taken into consideration all the assets and liabilities and passed the impugned order.
Court do not record in the order that you are at some point of time or at a brief point of time you are employed. No, when you are seeking shelter under the judgment of the Honorable Apex Court, you should read the entire judgment, not part of it, either of you. The whole judgment has to be considered. No, what is this conduct? What is this conduct?
They're all filed.
Is it because the client is in a position to engage an advocate? Time and again, you will come before the court.
It was filed in the year 2018.
All these provisions are not for people like your client and his client. It is for somebody who is really in need of it, not for the purpose of fighting it.
But I have placed my income tax assessment. I have,
My lord,
my income tax assessment as on 2012 and 13 is around 55 lakh rupees. It has come down 21-23. It has just reached zero, and thereafter it was regenerated in 16 lakh rupees in 21-22. Thereafter it was increased to 33 lakh
No,
rupees.
is it a case that you are living such a pathetic life?
That pathetic life was due to the
No, is it so?
not pathetic.
Then,
Not pathetic.
no, this is not for, equating both of you, like he is getting, if he is getting 9 crores, court should equally give you 4.5 crores.
Not equally, my lord. I'm not even asked that.
And what is this bargain? Is this the
Not
purport of
bargain.
it? When the Supreme Court said that there should be, the lifestyle has to be taken, it is not this way. Where a person who is getting her salary of 35 lakhs per annum and also getting 90,000 per month is not sufficient for you. And a person who is having 8 crores, he can't give 90,000 to the wife, he files a petition. Both the petitions I will dismiss with exemplary cause. 1 lakh on you and 5 lakhs on him.
My lord, let me point out.
And that also allows the court below to conduct a specific inquiry into all your suppression and misrepresentation of facts.
Yes.
Let that application
One
be decided.
application I have already filed, 340 application. I
Let
have
it be
already filed.
decided. Your application,
That may be.
My
done.
lord,
his application, your application.
but
Let
my-
him also come up with an application.
Much obliged.
Did you file an application for suppression of facts?
my lord, and it's
I-
going on
against
day-to-day basis, even today.
No.
Against the
We will,
husband.
we will ask the court,
Yes,
to
let
pass
it
an
be
order on
examined.
that.
Yes, my
And
lord.
then let all the litigants understand.
Yes, my lord.
Don't play with the process of the court. like
Definitely, my
this.
lord. I'm more up for it. I would be more than happy to do it, my lord. My lord, but my contention is otherwise.
Application was-
This is the,
There are so many people, please understand.
yes, my, that there are a lot of people
There
waiting
are
in
so
the
many
queue.
people who
Yes,
for
ma'am.
their basic necessities in life and to take care, to lead their life,
Yes.
they're fighting for it.
Ma'am.
And for them, for all of you, it has become a
Ma'am,
kind of.
My lord, as a husband, my lord, I did everything what I could do. Difficulty is that her expectations
Please
are
come.
so much. My lord, one more circumstance, assets and liability affidavit which is filed in 2022, it is full of lies. Let me point out that.
Don't have
And-
to point out, court will take care. Point an file an application before the
But
trial court.
the court is
and the
imposing a
trial
cost.
court- Trial court will decide it first.
Yes.
Within a month, it should be decided.
Well, time-
And both of
I
you
have
should
already
It is
filed
time
an
bound.
application
This
for
court
the
has made it
application
time
method.
bound, which will be completed in 3 months' time. That's the last chance given. That order is already passed. 3 months upper limit, which is passed 1 month back, only 2 months are
Along with
remaining.
it, this will also be passed.
Yes,
ma'am.
yes, let it be done, but my contention is that, my lord, I'm not liable to be facing this order because I'm a victim, my lord. This lady, not only that, with the little cross examination, what has been done, lot of falsehood has already come to the fore. My lord, just consider assets and liability affidavit, which is filed in 2022, not in 2018. They are also full of lies. She says she's earning 2 lakhs rupees per annum. That is the foundation for the learned just to pass an order. My lord, this is their
Agreed,
conduct.
but the orders
I
passed
accept-
in MC number. In,
But few more circumstances, my lord, and there are number of judges of various high courts which has said very clearly, if the wife is earning, the
once the court passes an order on that, whatever that is paid to her shall be recovered.
my lord, but difficulty is that, my lord, I am not liable to pay. This is not my conduct. Let them point out one small falsehood on my part. I am
Lord,
facing
there is a-
cross examination
I have
every day.
already filed one
My lord,
340.
am
Both
I-
of you will be arguing at the cost of your clients. If you stop here, it will be
Well,
fine.
just one request, my lord,
Yes.
let me cite number of judges, which is already part of the compilation. If different high courts are taken a view that if the wife is earning, especially in a case like this, she should not be given the liberty of getting the maintenance like this, my lord. She is earning 33 lakhs. She is not,
No, it is a penalty-like maintenance. There is a direction by the
yes,
court
my lord.
that the matter will be decided in 1 month.
Yes,
And even before 1 month, again, you, both of you will come to the High Court by filing 2 petitions. You can't wait. You can't wait for a month.
I would
You
wait.
can't argue the
My
matter
lord,
before the trial
I
court.
would rather wait for the entire trial to get over in 2 months' time. That is the timeline set by this court. I'm more than happy.
Please wait, please wait.
We are coming every day to conduct the trial. Even yesterday trial was conducted. I was doing cross. Today also it is listed. We are cooperating to the maximum extent. Not only that, my lord,
The
One submission, my lord.
IA number,
Only one submission, my lord. 3 months time was given. He filed 2 memos. He stalled the entire proceedings to be done before the second additional family court. It was referred to the principal judge. There it came back to this honorable court for administrative activity.
what has happened to that?
it is transferred. It is transferred, my lord. That is, my lord, not only that. Let me point out one circumstance, my lord. I made a chart.
I think we should let him complete.
Yes, ma'am. Let him do. Yes, sir.
In the month of in the month of June, he filed a memo. From June till today, no proceedings are. The direction was in the month of April. April also nothing has gone. There was objections and the objection was not recorded. This is the allegation which is put forth by him before the presiding officer and against the presiding officer also. I have submitted that memo also. Thereafter, presiding officer sent back on 13th itself, it has sent back the file reference means letter to the principal judge family court. Family court has sent back that letter asking for a clarification by this honorable court. And it has been put forth before this honorable court. As this honorable court directed, it is only a registry which has to be taking care of all these memo, all these letters. So it has been kept before the administrative judge. And thereafter, administrative judge about last week, it was resent to the principal judge to transfer to the first additional family court. And first additional family court took the matter.
Please come. The registry, it is submitted that after the orders or earlier orders are passed by this court, when the earlier order was passed by the court, the matter was pending before
Pending for second
My
additional
lord,
second additional.
family court.
my lord, I need to say quite a bit about this kind of conduct, my lord.
No, no,
Well,
you can state second additional
Family court.
family court. And later, basing on a request made by the husband and on the allegation that
We
the
never
wife.
made any request, my lord.
Hmm?
We simply filed a memo. We never, therefore I wanted to point out.
Oh, what memo?
Well, my lord could see page number 675. There at least 7 memos are filed by us to indicate what is transpiring in the trial court on day-to-day basis.
The-
My lord, 675, my lord, I come to Bangalore 17 times to face the cross-examination, which is not
The-
conducted.
No, what you have to
This
understand
is my cooperation, my lord.
because you are non-resident of Bangalore, the cases will not be done on a priority for you.
No, not like that.
That, please write, like it is submitted that later, the matter was transferred to the other court. Registry is, shall place before the court, the report that is received from the family court judge and what has transpired later. As looking at this case, both the wife and husband are fighting tooth and nail and also are coming up with several applications before the court. And this court wants to know what has transpired in the said case, as the registry shall place the report before this court to the registrar judicial tomorrow,
Tomorrow, Monday or?
Monday.
March.
Then before,
Appearing for the
and
petition,
KBS,
appearing for the petitioner, my lord, kindly pass over the matter, will furnish the memo.
We have made the entire payment as per settlement. They are supposed to file a memo reporting this.
Afternoon, pass over. Yes, next.
till number 5. Dhananjay Kumar, for petitioner,
Appearing for petitions. my
Suresh
lord.
Kumar Acharya,
What about the arrears of maintenance?
Lord, we have already paid 3,70,000 arrears till date. My lord, I would like to make one submission on this end. My lord, on the day the child was born, till date, the father has not seen the
We will
child.
not, we'll go to that later. No, there is an order. What was the order of the court?
We had to pay 8,50,000.
So that you have to first comply with, and then
Um,
you tell the court what you want. Then we'll pass an
My
order.
lord, we have.
that,
As on 31st, the memo for calculation, 9,70,000 is due up to the
My
month
lord,
of
we are
May.
seeking for the modification in the orders, my lord. Now, I would like to bring to the notice of this court that already the date the child was born, father has not seen the child. Now the child is major. And at the time the order was passed for the maintenance, kindly look into the page number 12, my lord. Page number 12 of Criminal Miscellaneous 52/2016. In this case, it has been stated clearly that it is clearly observed that the mother of the petitioner is a government servant having a better future and having the responsibility of maintaining the minor child. Considering the responsibility of the mother of the petitioner, a permanent alimony of 6 lakh has been awarded. At that time, my lord, when the divorce petition came to end, we have already paid 6 lakh as a permanent alimony, considering the child's well-being.
Permanent alimony and child welfare are not one and the same.
My lord,
What you're entitled to pay to the wife is entitled.
no, my lord, the council is trying to stress is that they have considered the responsibility of maintaining the minor child.
Then what about the wife for permanent?
She is already a government employee, my lord. She is drawing a salary of more than 70,000 per month. Wherein the petitioner who is not at all having a proper job, he had a business 15 years back, which he had.
The needs of the children are not, they are not constant. It keeps on changing. And
Yes, my
based
lord,
on
we
that, they
agree
can-
to that.
Now, what is wrong with the order? Please come to the present order.
Yes, my lord. My lord, the payment of what has been asked, that is 8,50,000. We are ready to pay 5,000 from the 5,000 per month, my lord, because the petitioner is already having his own family. He has 2 female kids. He has to look after them, and he has no proper job on his end to take care of his own family.
Where do you get that? Please come to the relevant.
Yes, my lord.
Where is the relevant portion of that observation by the trial court
Yes.
with regard to your income?
The order paragraph, second paragraph onwards, the finding starts, my lord. 138 criminal cases has been filed, my lord, for recovery of, my lord, 9 lakhs, 10 lakhs and odd.
What is that?
For 138 negotiable instrument, he's a professional money lender, my lord, and 138 cases, 10 cases are pending.
My lord.
He is persuading that.
Hmm.
He is persuading it. That has been, finding is given in the second
These
paragraph.
cases are not against him, my lord. It is against the.
He has not
person-
produced any material, that it
doesn't
is not
have any-
against him.
This
We have
conclusion
produced the
is, my
material.
lord, that he doesn't.
Court
have
has taken
sufficient
note of
income
it.
Because,
Simultaneously, both of you can't argue. When one
Please.
counsel is arguing, please maintain silence.
my lord, this clear, as the Lord Counsel has already pointed out, he has many cases in his name, my lord. because he has lended several lakhs of money to the borrowers who have not returned back the money. And since then, he is having a he is facing financially, he is not able to sustain himself, he is not able to maintain his family, my lord. And
Please come to the order and point out about what is your case about the income.
My lord, para number 20 of criminal miscellaneous, page number 20, para number 14. In this, it is clearly stated that the government employee and her designation as a warden in social welfare department with a gross salary of 50,000.
Why are you going to her income about your income? Against you, the order is passed.
Yes, madam. My lord, para number 10 of the criminal miscellaneous case. My lord, in this, they have not mentioned the specific amount.
And then you should say that, what is your income and how is it difficult for you to pay? Just like that, why would the court grant an order?
My lord, initially, like he has already mentioned, he was financially stable.
For that, we have to look at the income tax returns, your bank statements, which you are supposed to file. Why you have not filed?
We will produce in the next state, my lord, if it is necessary to show that he's not able to
You
maintain.
should have
himself.
done by this time. Criminal miscellaneous of 2016, we are here in 2024, which amounts you have not paid till now. No, even assuming that it is 5,000, how much is the amount? When is the application filed? In the year 2016, that is 8 years.
Yes, my lord, we are ready to pay the amount of
But
5,000
then
if it is
to pay,
calculated.
who stopped you from some amount you have to pay?
We have already paid 3,70,000 till date, my lord. After the order, was on 6/11/23, this honorable court has ordered directing the payment of 8,50,000 and we have paid 3,70,000 till date.
This matter was argued and my lord, after hearing the matter, my lord, this court has directed the my lord to pay the 8,50,000. There is
8 lakh.
order. That order is violated. So my lord, she is not entitled for the relief. They have not filed an application for modification. The court has said that he has not produced any iota of evidence.
My lord.
And moreover, there is a
we are
delay is
given the
not convinced, my lord.
opportunity
There
to
is a delay
produce-
of more than.
Can't argue when he is arguing. How will it go on?
Sorry.
There is a huge delay. Delay is also not properly explained. I have filed the counter affidavit. Kindly look at the reasons offered for condonation of delay.
1 minute. No, that itself, 5,000 itself would come to 4,80,000.
We are ready to pay that amount, my lord. Till
First
that
of all,
amount.
pay that amount and then make your submission. Pose
My
this matter
lord.
next week. By the time the petitioner
My
shall
lord,
deposit
kindly
an amount
specify
of
the
this
amount that has to be paid.
1,80,000 by the next date of hearing. Then we will hear you.
Yes, my lord.
Huh? Oh,
Last matter on 20th minute,
28th, 22nd.
22nd.
Yes.
Cell number
Much
6,
obliged, my lord.
Anupama Bodoli, an appellant.
Yes. No, that's the only issue. As on the date that, no, that's the same case, no?
Yes,
That notification has come on which date and,
the notification only said that it is prospective.
yes,
So since it is prospective, appeal lies to this court only.
no, prospective is for cause of action to this court. Now, when is that date?
13/3/2023,
17?
13/3/2024.
13/3/2024. And when did you file this appeal?
No, your lordship has to take the date of the order.
No.
The date of the order is the,
No, I think we have to look at the day you have come to this court.
no, that is what I pointed out. There's a constitution bench judgment. of the-
Let's see that.
Would your lordship kindly look at, just give her that, Karnataka Civil Courts Act. Just have a look at Civil Courts Act, where the appeal lies from an order of the single senior civil judge. This one,
Yes.
section 19. Yeah, give that. This is the one.
Would your lordship kindly look at Civil Courts Act?
Yes.
Please look at internal page 15.
Hmm. Yes.
Section 19, appeals from decrees and orders passed by the senior civil judge in original suit and proceedings of civil nature shall, when such appeals are allowed by law, lie to district court which is less than 10 lakhs and to the high court in other cases. This is one. Then your lordship may look at the constitution bench judgment. What is the relevant provision that has to be the cutoff?
Yes.
1957 Supreme Court,
Yes.
page 540. You've submitted it? Okay. I think it's already submitted to your lordship.
Yes. Yes. 140.
Gari Kapati Veeraya versus Subbaya Chowdhury and others.
Which para number?
I'll just come to that. Just your lordship may just look at the first paragraph, then I will take your lordship
Yes.
to para number 23. Lord, here what happened was a suit arose from the civil judges court in Bapatla. Appeal in that time, since Andhra Pradesh High Court had not yet been formed, appeal was to the Madras High Court. The Madras High Court decided one way or the other and remanded the matter back. Question was whether appeal lies from that to the Supreme Court or whether it has to. Your lordship may look at the, please look at the first paragraph. This is an application for special leave from the judgment passed on so-and-so by the High Court of Andhra. The suit out of which the application arises was instituted in the subcourt of Bapatla, which was then within the jurisdiction of the Madras High Court. The judgment of the trial court was passed on so-and-so dismissing the suit. The plaintiff appealed on so-and-so. Andhra state was formed and a new high court was established under section 28 of the Andhra State Act. And apparently the appeal stood transferred to the High Court of Andhra under the provisions of. On so-and-so, the High Court of Andhra accepted the appeal and reversed the decree of the trial court. The application for leave to appeal to this court was dismissed on the ground inter alia that the value of the property was only 11,400 and did not come up to the amount of 20,000 rupees.
Yes.
Then please come to para 23. From the decision cited above, the principles, following principles clearly emerge that the legal pursuit of remedy, suit or appeal and second appeal are really but steps in a series of proceedings, all connected by an intrinsic unity. 2, the right of appeal is not merely of procedure, but of a substantive right. The institution of a suit carries with it the implications that the right of appeals then in force are preserved to the parties. And 4 is what is important. The right of appeal is a vested right, and such a right to enter the superior court accrues to the litigant and exists on and from the date when the list commences, and although it may be actually exercised when the adverse judgment is pronounced, such a right is to be governed by the law prevailing at the date of institution of the suit or proceeding and not by the law that prevails on the date of its decision or at the date of the filing of the appeal. So therefore, I am saying, regardless of when this order came to be, when this appeal was filed, I am challenging your lordship's order of October 2023. On that date, my lord, the law was that an appeal would lie to the High Court.
So is it now?
May I just request your lordship sees on merits?
No, not on merit.
No, I'm just saying.
No,
that-
let me understand.
Please.
No, for example,
Yeah.
now somebody, some order is passed, maybe somewhere in January or February, and this rule have come in the month of May. Rules have come in the month of May. And somebody wants to question that order of January, for example, next year. Because then there is no limitation, 227, people are coming up 2 years, 3 years.
Correct.
So as per this judgment now, when that order is passed in the month of January, so as on that day, the new rules have not come, but still after 2 years also, the appeal has to lie to the High Court.
No, that is left to the discretion of the court to say that within, if there is no time limit that is fixed,
No time
then it
limit.
must,
Let's say
no,
there's
that
no time limit.
227 supervisory jurisdiction, within a reasonable time it must be done, because even if there is no time limit fixed, your lordships would say that if you have not come within a reasonable amount of time,
No,
I will
when
relegate you to the new remedy that is
when
provided.
when you have a remedy of going before the court, why should you
But
come to the High
I'm
Court?
only telling your lordships that, that's why I said, if your lordship has 2 minutes on merits, how can a trial court pass an order under SARFACI It is completely barred under 35.
Oh, that
And
is-
Supreme
that
Court
is-
in 3-4 matters has clearly said that it steps outside the jurisdiction. One. Second, your lordship sees that
Yes,
a mortgage is executed by the plaintiff.
Hmm.
And the plaintiff files a suit asking for a declaration that it is not bound by that mortgage. Please look at that, my lord. I think that is what is, that will completely clinch the matter. Would your lordship look at the mortgage deed at page 189? Please look at the mortgage deed. Who is the party who has executed it at 192?
yes.
Page 192 is the mortgage deed.
Notification is issued circular that we have to, the position should be as prior to the notification.
Prior to the notification.
Circular is issued.
Oh, okay. Please look at 192, my lord.
Please come. The present appeal is filed. Agreed with the orders passed. First of all, the registry has raised an appeal with regard to the maintainability of the appeal in view of section 19(1) of the Karnataka Civil Court Act. Considering the circular issued, circular dated 5/7/2024, as it resolved to maintain the position obtained at the pre-notification stage and continue with the same position until the disposal of the writ petition, wherein that is WP number 17588 of 2024, where it states the operation and implementation of the Karnataka Civil Courts Amendment Act 2023. The office objections for the time being, it is the maintainability of the appeal is left open. Then coming to the merits of the matter. The present appeal is filed by the Assets Reconstructions Company. Agreed with an order passed by the page number.
Page number 30. Dated 31/10/2023.
With the order dated.
Huh?
2/9/2023.
29 also. Okay. It is by the order dated 2/9/23 and then extending it till further orders on 31/10/23.
Where have you contested it?
Your lordship sees, please look at page 30. I am the defendant number 1. NS filed wakalat so and so. Written statement is filed, and please look at my SO at page 266. 266 is my SO, in which I clearly say that under SARFACI this is not applicable. I mean, this is not maintainable. Page 266.
No, that on your petition to vacate that, the court had not passed any order.
No, that's what I'm saying. Please look. Till then, it was being extended from time to time. After I filed my statement of objections, the learned trial judge extends it till further orders.
Where do you get it?
Your page 30. Please look at 30. 610, I filed my statement of objections, my lord.
No representation for defendant number 1.
Where
The
is that?
written statement of defendant number 1 taken as not filed.
Where is your lordship
I am
looking?
reading 31/10/2023 order.
No, your lordship may look at the previous thing, my lord. On 610, I have filed my statement of objections. NS filed wakalat for and also objections to IA 1 and 2 on top of the page.
Yes.
That is where I say at 266. Then please look at 3110. IA filed for extension. Heard TI is extended till further orders. What about my 266 where I have said that it is not maintainable? Should he not have heard it at least?
No representation for the defendant number 1.
No, I know that, my lord. At least some date could have been extended till the next date, my lord. But then,
This happened on 12/12/2023.
yes.
And when was this writ petition filed? What are the steps taken by the defendant to get that order vacated?
Huh? This appeal was filed on 1st of July, my lord.
1st of July. What has happened after the 12/12/2023? When is the matter coming up? Reissue suit so much.
So there are other defendants. Your lordship looks at the plaint. There are many defendants, my lord. Please look at page 36.
Why the court is looking at us? There's no difficulty in passing an interim order in this. No, there is a procedure. Once then,
Very well, my lord. If
injunction
your
is
lordship at
granted-
least stays this till the next date of hearing, I will take steps to see that is done. I won't trouble your lordships. Maybe if your lordship suspends this order, there can't be such a kind of order, my lord. That's all I'm saying. It hurts the dignity of the court, my lord, that a trial court could stay a proceeding under SARFAESI. Please look at section 35 of SARFAESI.
I'm not on the merits of the matter.
That's all I'm saying. And who has filed the petition, my lord? The persons please look at page 36. The plaintiff is the mortgagor. Please look at page 36 for a minute, my lord. The plaintiff is Concord Investments. And what is the relief that is sought? That the mortgage deed is not binding. Please look at 36 and 52 relief. Declare that the mortgage deed dated 11/2/2021 executed in favor of so and so is not binding on the plaintiff firm. The person who executes it wants a declaration from the court that that mortgage deed is not executed by. If such kind of things are alive, then how will the bank and financial institutions be able to conduct business? And especially if the trial court grants an injunction against a bank or an asset reconstruction company. I can understand if it's a declaration in respect of some other property somebody else has executed, don't hold that against me, I can understand. The man who, the partnership that has executed the mortgage, taken 58 crores loan.
I can understand all your arguments. It's on the merits of the matter.
Please.
No, the difficulty what I'm trying to tell you, which you're not understanding.
No, I
here,
understand.
What you're not understanding is, no, whether it is a right or a wrong order, for everything, there is a procedure contemplated
Please,
under the act.
please.
An interim injunction is granted. It has to be vacated. You filed a petition. On that day, when the extension has to be done, your advocate was not present
Present.
before the court. Court has adjourned it. That was when, in the month of December 2012. What has
23.
happened? 23. What has happened till now to here? Here the court will definitely know there are so many orders have passed on the last week where straight away have allowed the appeal filed by them. But the
Your
bank saying
lordship,
that it is not
I
maintainable.
only think that this is a case on merits that deserves it. But if your
Yes, sir.
lordship feels that my conduct is standing in the way,
Not the
your-
conduct.
it is
Caesar.
conduct, because after
Not-
that I have not done anything, your lordship is saying.
That's what, because
for
there
the last
should-
6
There
months.
should be an order. There should be now, when your application is pending, court should pass an order, then this court will get a jurisdiction to say that that is right or wrong. No, that stage has not come according to the court.
May I request your lordships to just suspend it and send it back, my lord. I will see that your lordship may keep this for only 4 weeks and say,
No, what?
now what it says is the order now that I have impugned says still further orders. Your lordship may restrict it.
No, what this court will say is, will pass an order today and direct the court to decide the application itself within 2 weeks.
Please. And in the meantime, let it be suspended, my lord. Otherwise, otherwise I don't get any
But what
benefit
will
from it.
happen by suspending and sending it back will not arise because we have to issue notice to the respondents.
No, I'm only for 2 weeks, my lord. Only for 2 weeks.
Keeping it pending for years together.
I will take out, I will
decided.
take out notice on the advocate who's representing the
Pending
trial
here,
court.
please come. The appellant is a defendant agreed by the order passed by the trial court, wherein the court had granted injunction and later, after filing the objections, the same has been
Extended
extended
till
until
further order.
further orders. It is submitted that when the surface proceedings are initiated, the suit is not maintainable, and without even considering the same court had granted injunction, and further when objections are filed by the bank,
Saying
without-
there's a bar under 35 of the
the
SARFAESI.
objections were filed by the bank that is such a suit is not maintainable in the light of section 34 of the Surface Act. All these aspects were not considered and it is extended until further orders. As such, the said order needs to be suspended or like set aside. This court had heard the senior counsel appearing for the appellant and also peruse the record placed before the court. The court had granted an injunction
On
on
2/9/20.
2023. Thereafter, It was extended on 6/10/2023. On that day, a wakalat is filed on behalf of the appellant and also objections were filed to I number 1 and 2. Then after 6/10/2023, the matter came upon 31/10/2023. On that day, the case was called. The court observes that the counsel for the plaintiff is present, filed IA for extension of the interim order, and it is extended till further orders. Court further observes that no representation for defendant number 1. Written statement of defendant number taken as not filed. Reissue suit summons to defendants number 2 to 9 by RPAD. Then the matter was adjourned to 12/12/2023. On that day, the court, as per the proceedings, it shows that there was an order to reissue suit summons to defendant numbers 2 to 9 by RPAD. Then the matter was listed on 22/2/2004, 21/4/2024. The senior counsel has submitted his arguments on the merits of the matter. This court is not at all inclined to go into the merits. First, when an injunction is granted, the remedy is available to the defendant to seek vacation of the said order. He has filed his objections. Then on the day immediately after the second day, when the matter came up, he was not present before the court. And the court had extended the interim, the interim order, the injunction until further orders. The application that is filed to vacate the said order is still pending before the trial court. And this court is not inclined to cannot entertain this appeal when the available remedies are not exhausted by the appellant. It is submitted by the senior counsel that the order may be suspended for 2 weeks and they would take appropriate steps. When the appeal itself cannot be entertained, question of suspending the order would not arise. Considering all these factors, this court deems it appropriate to direct the trial court to consider the application that is filed
No,
by the
to
defendant.
consider IA number 1 and 2
To consider IA number 1 and 2.
and the
within
objections filed by the appellant.
And the objections filed by the appellant within a period of 2 weeks from the date of receipt of the copy of the order.
And to dispose of the IA number 1 and 2 on merits. Your lordship may just say that.
The appeal shall be, that IA shall be, the order shall be passed on merits. Yes. Accordingly disposed of. As no adverse orders are passed against the respondent, this court is not issuing notice to the respondent plaintiff as the speedy, as disposal of the case is interest in of both the parties.
Public.
Till number 7, Chandana Tarika K, appellant. P. Sadashiva,
Appellant,
RAR 126.
my lord, the first matter,
Yes.
the respondent number 1 died, my lord, and the 2 to 6 are the LRs are already on record.
Where is that
And-
memo?
It is in the file, my lord.
When did you file?
It was nama memo. Munchid.
A memo is filed stating that the respondent is no more and
Respondent number 1,
respondent number 1 is no
One.
more. And the legal representatives of the respondent 1 are respondent number 2 to 6 who are already on record. Hence, they may be treated as the legal representatives of deceased respondent number 1 accordingly. The memo is taken on record and the respondent number 2 to 6 are taken on record as treated as LRs of respondent number 1. Yes.
my lord, in the next matter,
Mm.
5461, also respondent number 1 died and her LRs are already on record as respondent 2
Same
and
order
3.
in 7.1 also.
My lord, a memo is being filed.
Same memo is filed, same order on 7.1. Then 7.2, now
7.2,
nothing
there
is
is,
there. Yes,
yes,
please argue the matter.
yes,
What is the suit for?
yes. So the claim,
No, there are three appeals.
Three appeals, ma'am.
So MFA
MFA
Five, four-
5460,
uh,
5461
uh,
and 5462,
uh,
3 appeals.
uh.
My lord, all these arise,
Rising out of the same suit?
no,
Oh.
different suits.
Please
Different
give the
suit-
numbers.
Yes.
5460 arises out of?
5460 arises out of AS number 13 of 2014, which is which arises out of AC number 2 of 2005.
2 of 2005.
Yes,
Next, 5461?
5461 is not in on the notes. 1 second. Five, four, six, one, AS number 10 of 2014.
10 of
Uh,
2014.
1 second. 5461. Yes.
Turn this.
AS 10 of 2014 and AC number is 4 of 2005.
2005.
Yes.
Next appeal?
Next appeal is AS number 9 of 2014,
Hmm.
AC number 3 of 2005.
Please come to the order.
Yes,
It's number 13 of 14.
yes. May I take your lordship to 5460, madam?
Yes.
First of the,
Yes. What is this AC number 2 of 2005?
AC number 2 of, there was an agreement between the appellant and the respondent to sell standing timber. That is, the agreement is dated 30/12/1984.
No, is there any connection between all this? What is the
Yes.
connection?
Connection is, the owner is the same,
Appellant is the same.
appellant is the same.
Defendants are different.
Dependents are different.
Hmm.
In 2 of the appeals, the respondents were husband and wife, separate, that's separate.
So
There was
now
a
let's go to this order at page 51.
page,
That is the arbitration case.
yes.
It is 15,43,699.
My lord,
Damages.
yes,
Hmm.
15 lakh,
Hmm.
43,699.28 is the claim.
Yes.
Lord, may I take your lordship through the arbitration suit judgment? my lord?
Yes, yes. So that
It-
it will be clear.
Yes. It starts at ink page 14.
Yes.
Good. The brief facts. The impugned award arises out of the agreement between the plaintiff and defendant number 1 dated 30/12/1984. Under the agreement,
Where are you reading?
my lord, the
I think
judge
it says page 51.
51.
Where
That
is
is the award, not the award.
I'm looking at the award and the issues, where is the reasoning start?
Yes. 1 second. My lord, there is complete trial court records were received and there is a paper book, 3 paper books were,
Prepare.
yes. That is the records of the arbitrator.
Where are
I
they?
shall read from the
Yes.
award.
No, that is not there, but it is there?
My lords, if I may make one submission.
Yes.
Insofar as my lords 7.1 and 7.2, my lords, I appear on behalf of the respondents.
Yes.
Now, my lords, I do not have the complete copies of both the MFAs and neither do I have the copy of the lower court, my lords, the paper book. That has not been served upon.
My lord, the appeal memo is served and the records of the records from the court, I think it is available. In the court records, even the award is available with all the annexures, exhibits.
My lords, in so far as the appeal copy is concerned, my lords, I have received an incomplete copy as my lords. Largely, the pages are missing. I may be
When
permitted
did you
to,
file wakalat?
my lords, the wakalat was filed, my lords,
It's an MFA of 2016.
20.
Now, how
Please,
can,
please.
what submission is it now? How many times it must have come before the court? You should have
That's
informed the court long back.
a short accommodation, my lords. In so far as the paper book, my lords, that may be served upon me, my lords. I will.
Paper book have not filed.
He has not
I have
filed any
not
paper
filed
book.
paper book.
My lords, then I may be given time to, my lords, secure the complete records. And I'll, my lords, appear before your lordships. In so far as
So many
7.1 is.
times, even our last occasion also, it has come, even before this court, it has come up twice. You didn't appear on any of that day.
My lords, on last occasion, my lords, I had mentioned that R1 has deceased. They were to bring
Was this
the.
matter on 2nd September? On the top of the list, on that, by that date, no further adjournment will be granted.
Please, please, my lord.
My lord, maybe posted for hearing,
Yes, on that date.
please.
Please.
Number 8. For petitioner.
What has happened in that? Have you seen that record? You wanted to, somebody wants to see that day?
No, my lord. The court wished to see the record to ascertain as to whether Lok Adalat was held.
Received.
Trial court record. There is order sheet.
Annexure के order dated. Lokaat order dated. 22/12/2015. In the criminal, Miss 38/2014.
Yes, give that. What is the date you said?
22/12/2015. Typed matter, my lord. 22/12/2015. Order sheet, in the order sheet itself, it's a typed matter.
Give it to him. Both of you can see.
My lord, certified copy, it is not found.
Look at it, there's the original record.
Yes, my lord, but certified copy is issued, I have produced the certified copy. Way back in the year 2016, it is taken. It is not known how this is, because Lords may kindly peruse from my writ petition. I have produced the
Just look
certified.
at the paper at least. That is not something which is constructed now. It's an old document.
But I'm not in a position to say anything because the certified copy shows that it is, but even then, my lord, even then, if your lordship finds that in the.
No,
original
the
record,
grounds which are raised by you is one, no Lok Adalat was done on that day.
no reference was made.
Made. No, no, that is one. Number two is that the judicial member has not signed. It's only the advocate conciliator who has signed.
No, judicial member signed, advocate conciliator blank.
Advocate, that is there.
That is my.
No, that is there in that order now. See.
That I have seen, my lord, I have seen, but the certified copy, your lords may kindly peruse. I don't know how, whether there was a local constituted or not, is not found from the records because it is, the matter has not been.
Look at the signature of your client.
Huh?
Look at the signature of your client in the joint memo.
Signature is there.
Now let us see from this, from this petition, where did he sign?
I am not disputing.
No, let us just see.
I am not disputing that the petitioner has not signed.
Then what are you disputing?
Second petitioner is not there. Petition was filed by two persons, wife and son.
Who has signed according to you?
Only first petitioner signed.
Wife will sign. What is the,
Wife has signed.
what is the age of the son as on that day?
He was major.
2 years.
Huh?
2 years.
He was major.
Uh.
And my lord, your lordship will kindly see.
And he had no locus standi to pursue the CMIS petition under 125 CRPC because he was a major by that time. He had lost the limits.
But my lord, there was no reference. There was no application for.
Having signed all these documents, your client can't afford to say all these before the court. This is a pure abuse of process.
No, with great respect, it is based on.
See, please come to the grounds that you're taken. Then the court have to view it very seriously. What did he say? Let's see. What is the case of your client? Let's read it.
Now, your lords may kindly peruse Annexure K order.
No, not the order. Before that, let us see what is that you're trying to say in this petition. Let us understand it. Just like that, you can't attribute malafidis to the court. The respondent induced fraud,
Induced.
misrepresentation,
my
and
case.
coercion got filed joint memo before the Lok Adalat. What is meant by got filed? And behind the back of the petitioner number 2 and Lok Adalat. So where is your case that you have not signed it? What is this got filing?
No, I have contended before this honorable court, my lord.
That's what I'm saying, before this court only. What do you mean by this para number 12 at page number 4 of your petition?
No, I have stated the facts which led to this order. I have stated. Your lordship are.
No, when you are alleging fraud, it is not just a simple affidavit. When you are alleging fraud, the circumstances have to be explained to the court.
No, I have stated that the respondent has induced the petitioner number 1.
How, when and where?
And on the ground that there is a partition suit pending between the son and the.
You say, let us see that.
I have stated, my lord.
Where is, please tell the court. If this is the manner in which the proceedings have to go on, then there is no finality to anything.
In fact, the right of the second petitioner under that original suit is not disturbed. No prejudice is caused. It is evident from joint memo. It is stated he has liberty to pursue his right in that original suit for partition.
Paragraph
Therefore,
24,
no-
my lord, I have.
Paragraph number?
24.
Let's see.
Petitioner number 1 was not properly advised and explained of the consequences of the alleged compromise, and petitioner number 2 was not informed in that behalf. The petitioner submit that fraud, misrepresentation, and undue influence played by respondent resulted in filing compromise petition. The respondent also made false assurances and induced the petitioner number 1, promising that the civil suit between himself and petitioner number 2 will be settled.
No, no, what is
Giving
the
share in
extent of, what is the information of the client saying before the court that no Lok Adalat was at all constituted on that day?
Further I have contended.
Huh?
Further I have contended.
I'm looking at para 23. Basing on what your client is saying this? How, what is her knowledge that no Lok Adalat was held on that day? When you're making allegations, you should know it perfectly what it is.
The proceeding itself, my lord, shows.
Which proceedings?
The Lokaat proceeding shows
Give that.
there was no
No,
reference.
sometime you want to again reconcile on certain
No,
things.
no.
To come to make this,
Your lordship may kindly call for explanation because Annexure K issued to me. Annexure K issued to me, kindly peruse.
first of all, instead of asking for all that, where are the bona fides of your client? You file a joint memo, you appear before every authority, you keep quiet, and now you come before the court and tell the court that some fraud is played on you.
No, thereafter, my lord, I filed an application before the same court. I filed an application.
When was the order? When did you do it?
22/12.
Uh,
22/12. Thereafter, I filed an application.
When?
That is on next, my lord, I have produced this.
After 1 month, my lord.
No, before the next date of hearing. And she has taken the no objection from the earlier counsel and filed application. Your lordship find, I filed application immediately on, I got advancement application was filed, that your lordship find from the order sheet itself. Your lordship may kindly peruse.
So what is the prejudice that is caused to her now by virtue of this order? What is the prejudice that is caused to her by virtue of this order?
Prejudice, my lord, in the compromise petition, the divorce proceeding is sought to be withdrawn. There was a divorce proceeding before the family court. Order was passed by the family court in favor of.
Have you received 10 lakhs?
No, I have not taken.
Her son tried to withdraw that, court rejected,
I have not
and
taken.
it is still lying in the court, my lord.
You have
And-
deposited?
Yes, yes, my lord.
The amount he has deposited, after this compromise, he has deposited after 2 months.
What is the age of these parties?
My lord, the
Please, your lord.
Age?
Age of the party, my lord. Husband died, my lord. Husband died in,
wife is 54 years old. When this.
wife is, my lord, I have stated the age, correct age is 54 years as on 17.
When did he die?
18 to 19, 2018.
18.
2000?
18. 18th February 2018.
When is the order passed in this petition?
25/12/2015, 3 years earlier.
No, this divorce, my lord, your lordship will kindly see. I have stated.
But
that-
in her application, which
I have also
she
stated
filed,
that aspect of the matter. Divorce petition filed by the husband was allowed, against which the petitioner number 1 preferred MFA before this honorable court. In November 2015, interim order of stay was granted. And in December, this compromise.
in fact, the Honorable Family Court awarded 5 lakhs, my lord, as
Interim order-
permanent alimony.
Interim order of
But
stay was
he
granted.
deposited 10 lakhs. He agreed for 5 lakhs enhancement and he deposited 10 lakhs.
And before this honorable court, well, I have filed the additional documents. Before this honorable court, division bench has allowed my appeal. MFA is allowed, divorce is set aside.
But there they suppress the material fact that she has appeared before the Lok Adalat and she has undertaken to withdraw the MFA. They suppress that fact. And it is for that reason the MFA was allowed and now it
MFA is allowed,
before,
I have produced the certified copy. Your
that is
lordship will
before
kindly
Honorable
see.
Supreme Court, my lord.
Before Lok Adalat, in the trial court, what is thought to be settled is MFA before this honorable court.
ಹೌದು.
pending before this honorable court. Division bench pending before this honorable court. The joint memo may kindly be perused.
Where are the Lok Adalat proceedings, sir?
Please.
Yes. I've asked for the court as well as the Lok Adalat. Where are the Lok Adalat one? Before the Lok Adalat.
No, there is no other papers, my lord.
No, there won't be other papers in fact.
Not papers, they should have like Lok Adalat conducted on so and so date, some
No.
material will be there.
No, they
before
will
this.
mention in the regular order sheet of the case that is pending before the court. And
Lok
what
Adalat,
happens, my lord, in,
it's not by the legal services authority.
no, it is in the taluk committees would have held every day, my lord. Daily basis lok adalats
It
in
will be
the
there.
mafasil courts, my lord.
Oh,
That's the reason why any day parties or advocates can approach and request the court to take up the matter and close it off when they arrive at some settlement.
that I see,
With your lordship,
on this side.
lordship kindly. Because of the certified copy blank, I have my own, my lord, because whether there was a local constituted, whether the advocate conciliator signed. Because if there is, otherwise, the certified copy may kindly be seen. Absolutely no doubt can be.
Where is the certified copy? Page
Annexure
number-
K at page 89. Starting from 83 at page 89.
Let's see, no. Bhagya HD. PK, it appears that something is wrong here. I think it's a freshly signed one. Where are the, when have you obtained?
Please, your lordship.
Please come, this court by order dated,
2/16, I obtained the certified copy.
by order dated, what is the date of the order?
25.
By this court. 20, on 18/7/2024, has directed the Registrar Judicial to call for the records of the trial court. Today, the records are placed before the court. It was a contention of the learned counsel for the petitioner that the name in the order, Lok Adalat, the name of the judicial conciliator, the signature of the judicial conciliator is present. But when it comes to the advocate conciliator, there was no signature. Now, when this court peruses the original record placed before the court, this court finds the signature of the advocate conciliator. This court had, the petitioner had obtained the certified copies on which date?
That is, my lord, on 17/2, my lord, 17/2/2016.
Certified copies were issued to the petitioner on 17/2/2016. And that Lok Adalat award is dated
22/12/2015.
22/12/2015. So when the original itself shows that there is a signature of the conciliator, why it is not present in an order that is granted? And it appears that there is something fishy in all this. The Registrar Judicial shall look into this and shall call for the necessary records and shall find out what has happened and what is this discrepancy in the certified copy at page number 90, and also the record that is placed before the court at page number 40. Page number 40, a report shall be of the order sheets of the trial court. The Registrar Judicial shall place a report before the court. Post this matter on September 2nd.
Lordship may say advocate conciliator.
Advocate conciliator.
Lord, if I am right, it's on page 89, my lord, not 99.
80?
89. It's on the page 89, the portion
That
of,
order is on 89.
not on 90, my lord.
Let us 80?
89.
Endorsement of certified copy is on 90, page number 90.
I'm
as-
looking at that. I'm looking.
Lordship,
80.
89/90.
The order is at 89
Yeah.
and at page 90 is the date of the
Endorsement.
Issue of
endorsement
certified copy.
certified copy. Yes. And it's very strange. How can this happen?
My lord, in Mafassil areas, what happens? Sometimes the advocate conciliator would be absent.
No, but it is, he has obtained it after 6 months from the date. of-
That is,
As a formality, to his sign would be obtained later.
6 months.
Not 6 months, my lord. I think.
Order is passed in somewhere in.
No, December.
no.
I think on 16th Feb they have
no,
taken.
25,
15-4.
no, 25/12 order passed. 12/6/1 applied, 17/1 taken.
No, they can't give a certified copy without the signatures, sir. How can they give?
No,
No, I can understand the same, immediately they have not obtained. When the certified copy is asked by somebody, at least at that point of time, signature will be obtained.
it appears,
Only they will give the
it
signature.
appears the advocate,
Before, and still there was one more date given for enabling the husband to deposit the money. So therefore, probably the judicial conciliator would have thought he will secure his signature later.
no, with great
We'll
respect.
find out from them.
What I-
Because these kind of things shouldn't happen in a judicial proceeding.
May I
It's like,
submit?
it is not,
What I
May I
sincerely
submit
feel, my
one-
lord, judicial conciliator's endorsement would hold
no,
sanctity.
Here,
than-
we are not on the point whether it is valid or not valid. Here it is when you give a certified copy, later there can't be any additions to that. Once an order
That
is
aspect may
granted.
be.
That's the only aspect.
Yes, my lord.
My lord, it appears on that day only judicial conciliator. Because
We'll see,
the
we'll see.
application filed is, the petitioner filed the application for recall, in which I find.
She's fighting even after husband's death also. That shows how strong she feels her case is.
No, divorce is cancelled, madam, set aside by the division bench
After
of
the death,
dishonored
my lord.
report.
It is set aside.
Yes.
It is set aside last year, my lord, in 2023, they suppressed the fact that
Is it
Carried it into the Supreme Court. Why?
That is
There are
carried, my lord.
suppression,
Yes,
not suppression,
Yes,
there is
lot
no
of
itself
suppression.
is
at-
filed before Supreme Court.
properties are there.
Properties are there.
Properties are there.
That's the
And
reason.
she is getting pension also. And now the impleading applicant as LR claims that there was a marriage with this husband during the pendency of the appeal. These are all things which intervened. for this.
Two original suits are pending in the Hassan courts, my lord, regarding
Properties are there.
property issues between the same.
About 22 properties.
Now the son is interested with that.
Son is interested with that.
Anyhow, son's right is always existing. He's having that right to have the.
But there is
property.
a defense taken by the LRs of husband saying that about
Divorce is-
paternity, my lord, about paternity, some applications regarding.
Oh.
That writ petition is also, the application rejected and writ petition is also rejected.
Because of that stand of them, they are fighting for this.
Exactly.
Yes.
Till number
Yes.
9.
Applied.
Samir SN for petitioner.
No representation on behalf of both the parties poses matter on 23rd of September. 23rd September. Yes.
Till number 10. Gautam Raghunath.
Happy for the petitioner in this matter, my lords. My lords, one submission.
Kushani Kumar.
My lords, we have initiated settlement in this matter, my lords. And there's 90% chances for reunion.
When do you want?
My lords, second week of September, my lords.
Poses matter on 18th of September. It is submitted that the compromise talks are going on between the parties. Yes, next.
Till number 11. Chandrasekhar KA. For petitioner Ashok Patil.
Yes,
File a memo for a deposit amount, arrears of amount,
you've deposited.
deposit.
Copies of annexures,
Huh?
I have not received from them.
You have not?
Copies of annexures, they not served to me. Only petition copy they have.
What is the order passed by this court?
My lord, copy sent by RPD and date of 8/8/2020.
You have deposited 1,40,000.
1,40,000.
Let her withdraw the money.
Kindly after next week, final disposal.
Huh?
Kindly after next week, my lord.
Huh?
Matter may be final disposal.
No, let her withdraw and we will dispose of. Let it happen and serve her one more copy of it. This court as per the order passed for this court, and council submits that he has deposited an amount of rupees 1,40,000 and how much you are depositing every month?
Arrears of the amount 1,40,000 already deposited.
Where is the order? When is the order passed?
Order dated 6/6/2024. Passed by the Istanbul court.
Strike of all that. This court by order dated 6/6/2024 has directed the petitioner to pay an amount of rupees 1,40,000 within a period of 3 months from the date of receipt of the copy of the order, and also to deposit an amount of rupees 10,000 per month by 5th of every succeeding month. Today, a memo is filed stating that he has already deposited an amount of rupees 1,40,000 and also continues to pay an amount of rupees 10,000. Land counsel appearing for the respondent while submits that she is yet to receive the papers in the writ petition. Considering all this, the petitioner shall serve the papers on the counsel for the respondent, and the respondent is at liberty to withdraw the amount deposited. Pose this matter on September 24th.
Till number 12. Internal Tariqa
I'm
ke.
correspondent to the
Petitioner,
petition.
Nagendra
I'm
Kumar.
filing my objection statement to this petition. Madam.
Hmm.
Because yesterday I filed my wakalat. And in this case, I have to call for all the records because they are separate certain facts. And they have mentioned in the petition that she is working, that is the respondent is working. She is not at all working now. Earlier she was working, my lord, she gave the
No, if they are
resignation.
saying that you are working, they have to file the material before the court. Why do you want adjournment?
But she has resigned now. After filing of
I
this
have
petition, she
resigned.
resigned.
Resigned the company, one thing is, and they have shown the salary slip, my lord, where they are showing that 4,57,000 is the monthly salary of the petitioner, my lord. Take home salary only they are showing that 1,57,000. More than that, 2,52,000, they have shown it as tax he is going to pay, my lord. Their own
So-
records, my lord.
Plus, that is the salary
is
slip
the
that is
very-
provided, that is on record. I have produced it.
That,
No, there should be some basis for anything.
On paper, that is 4
Not on
lakh. whatever.
paper, you have to tell
Please.
the court, a person who is getting 4.5 lakhs,
Please.
and his take home is 1.5 and remaining amount, if he's paying for taxes,
Please.
under which law?
But
even
that is
not
what is
1.5
deducted by the company and that is what is
Tell the
transferred.
court, what are
That
the
I-
heads?
I'll
is,
place it on record. I'll place my IT return. That is not an issue. my lord.
4,57,000, only 1,02,000 he's taking home, madam. That is what the documents they have filed. And moreover, assets and
What are the
liabilities,
deductions from that?
deductions, 2,52,000 tax only, and the rest of the amount.
Is the
madam,
company?
He is
Broadcom.
working in Broadcom, he's the
Broadcom.
principal engineer, not only 4 lakhs is drawing, my lord. What the petitioner says, my lord, it is more
By
than
the
8
next
lakhs
date of
salary per
hearing.
month.
By the next date of hearing, land counsel for the petition shall file an affidavit before this court stating what is the salary and what are the deductions and what is the take home salary. Pose this matter on August 28th. Yes, next,
Please, my lord, date, my lord.
13.
28th.
Please, oblige.
I am for the respondent party.
Yes.
Rahul is ready for applying.
Yes.
In this case, your lordship can see that the daughter has filed a suit for partition against a father and brothers. That suit came to be dismissed on the ground that during the lifetime of a father, if she is not entitled, then she preferred an appeal. During the period of pendency of the appeal, father passed away. The court comes to the conclusion that on the death of the father, his self-acquired properties, that the daughter is entitled for a share. Accordingly, a share was granted by the High Court. Then thereafter, your lordship said they filed a review petition. Review petition stating that
Before
No.
this court.
review petition
High
in the
Court.
same RFA.
Hmm.
They filed a review petition stating that no, during the pendency of the appeal, that the father has executed a will in favor of grandchildren. And in turn,
Did a bill in favor of?
grandchildren,
Hmm.
sons.
Hmm.
And they have obtained a letter of administration. Against that, now your lordship can see, we preferred an appeal before this court challenging the letter of.
That letter of it.
Please,
Yes.
your lordship can see section 263, my lord,
Give that.
my Indian succession.
Succession.
263. Revocation or annulment for just cause. Wherein your lordship can see class A and B, just cause shall be deemed to exist where the proceedings to obtain the grant were defective in substance, or the grant was obtained fraudulently by making a false suggestion or by concealing from the court something material or the case, or even if your lordship can say daughter is alive, everybody is there, without making them as a party, only the grandchildren have filed this case and obtained the payment. Because of that reason, your lordship can say have challenged. Even during the pendency of the appeal, they have executed it amounts to a list also. Then in your lordship can see the Honorable Supreme Court also held that.
What was, no, he was alive during the pendency of the RFA.
Please.
What was, he was a party to the RFA. What is his stand?
Grandchildren were not the party.
Not the grandchildren.
Brothers are the party.
Grandfather.
Grandfather, during the pendency, your lordship, they have not stated anything. They only.
Did the grandfather say that I intend to give this?
No, no. One, even your lordship can see in the RFA proceedings, my learned friend, colleague came and says that we have no objections to decree issued in respect of the properties of father. As per the consent only that decree was made. Then subsequently they have said my colleague was not aware regarding the execution of this will and obtaining the probate. Then thereafter your lordship said.
According to them, when was the will executed?
2015, my lord.
Huh?
2015, my lord.
They have not stated in the.
With regard to that will, the grandfather during his lifetime, before any of the proceedings, he has
No.
not disclosed it.
Not disclosed.
And what is the RFA was it was a compromise decree?
No.
No, my lord.
And on merits, when the court has come to the conclusion, they are entitled for a share in the father's property. At that time, my friend also said that I have no objection to grant the share in the property.
That was when was the order in RFA?
RFA order was passed on
Or at least year, which year?
24 only. 24 only. Review petition is also filed in the 24 only. I think next
And
Friday
the-
is review petition
And you
is.
said the grandfather died on?
Grandfather died on
2015, my 2015 itself, my lord.
after the execution. Within 3 months from the date of execution of the will, he passed away. Even the signature on the will, your lordship would say, does not belongs to the father.
The grant was made without citing the parties who ought to have been cited.
Without invoking a section.
When did you obtain this? This order is when?
This order,
That is on 25th October
October
2022.
By the time the RFA is pending.
RFA is pending.
And your father is a party to the RFA.
My father was a party to the proceedings.
RFA.
RS.
Yes, nothing has been disclosed by anyone.
No.
No, man.
So
May I please,
what should happen now?
the limited purpose, the appeal has to be considered, my lord. My lord, this appeal is challenging the grant, challenging the grant made by the probate court for probate, my lord. Probate is granted under the provisions of 276, my lord.
Correct.
Let's see.
A 276, under provision of 276, where probate was issued in favor of the respondent number 1 and 2, my lord. The 276, my lord. Probate was issued in favor of the respondents, my lord. Thereafter, during pendency of the probate proceedings.
When did you initiate probate proceedings?
2022, my lord. In the year 2022. Then we took a paper publication by virtue of the order passed by the probate court, inviting any objections by any party or interested parties to the property involved in the probate court, probate proceedings. There was no objection. There was no person was appeared before the probate court. Thereafter, probate was issued, my lord. When aggrieved party is not a party to the probate court, she cannot file an appeal under 299.
she has to go before the probate court by filing an option of the application 263. That
Let's-
has to be
Let's see.
exhausted. My lordship, may
Revocation
kindly.
or annulment for just.
Yes,
cause.
my lord.
Letters of administration.
My lordship, may kindly peruse 263.
Just cause shall be deemed to exist where the proceedings to obtain the grant for defective in substance or the grant was obtained fraudulently
Yes,
by
ma'am.
making a false suggestion or by concealing from the court something material to the case. So why you cannot go there under
Your lordship can see 299, I believe, sir.
299.
Please.
Yes, ma'am. Appeal provision is 299. If you are party to the proceedings
Let's see,
before the
let's
trial
see,
court.
let's read it. 299.
Appeal from orders of a district judge.
Yes.
Every order of the district judge, by virtue of the powers hereby conferred upon him, shall be subject to appeal to the High Court.
So why not this 263?
263, my lord, they have prepared and approached the trial court. Before filing of that, they have said that the appeal is not maintainable before this court, go before the court. Because of that reason, they have
No,
filed.
they might have said we should invite an order if the court is not understanding. No, let's again read 263.
But 263, your lordship can say.
Revocation or annulment for
Correct.
just cause. It can be revoked by the very same court.
Very soon. I have relied upon Supreme Court citations, my lord.
No, no,
She
provision
has
is
to
so
exhaust
clear.
remedy before the probate court by filing an application.
Provision is so clear, no
Yes, my
judgment
lord.
is required for that.
That's what, my lord.
But the trial court is refused to take the file on the.
We'll say that as for 263, it lies before the
Yes,
court and
my colleagues went there and they have said, but they have not considered because of that reason even.
now they'll
But-
consider.
I have
And
relied
even
upon
there is
Supreme
no
Court
fault.
citation as well as my lordship.
But
my-
when there is a provision available, no, this
Yes.
appeal they are referring
Yes.
to arising out of a contested matter. Or a person you ask for a probate, it is rejected, then that 290,
Yes, my lord.
299 will come.
299.
Please
If she
start.
had a party to the probate court, she could have filed an appeal, my lord. Not by filing an appeal under section 299, my lord.
Agreed with the orders passed in PNSC number 31 of 2022.
Liberty may be given to approach. the-
25th day of.
Because the limitation is there.
25th October.
Please.
2022. The appellant, who is not a party to the said proceedings, has come up before this court. It is submitted by the learned senior counsel appearing for the petitioner, appearing for the appellant that the appellant had filed a suit for suit for partition. When the said suit came to be dismissed, he had preferred
She, my.
he had preferred an appeal before this court, that is RFA number
RFA number 1106 of 14.
2014, which came to be disposed of on first day of February 2024, where this court had held that the appellant is entitled for a share. Is it so?
Yes, my lord.
Yes.
Appellant is entitled for a share. Now, this application is filed before the probate is obtained by the son of, which respondent is he?
The second respondent, my lord.
In the, not here,
Third respondent, my lord.
in the RFA.
Both sons of the second and third respondent
Third,
are the beneficiaries of the
second
bill.
and third respondent sons have filed an application before the
Probate.
probate court and obtained a probate saying that the grandfather has executed a will bequeathing the properties on the grandchildren, which are part of the
Appeal.
which is the suit schedule property in the RFA proceedings. The court had passed an order on 31 by way of impugned order, the court had allowed their application. Agreed thereby, the daughter, who is an appellant in the RFA, is before this court. Senior counsel appearing for the appellant submits that without any notice to all the affected parties, particularly in the light of the litigation pending between the parties with regard to the very same properties, without any notice to them, without making them a parties to that, the probate is obtained and the same has to be set aside. He had relied on section 266, No,
63,
which
ma'am.
provision you rely?
263,
276.
please,
He relied on section
299.
290, not 299.
263 of
1 minute.
Revocation.
revocation or annulment of the probate.
He relied on section 263 of the Indian Succession Act. He submits that when they have, not necessarily, he submits that the said order is liable to be set aside. It is submitted that now a review is also pending before this court in RFA, which is filed by the
Appellants.
you have filed the review to
Yes,
bring this.
no,
to the
we
law.
have filed
They
review.
have filed the review.
Is
That's why
filed by
number
the,
2 only.
is filed by
Fathers.
the
Fathers of the
fathers of the
respondents, my lord.
respondents.
In RP number, my lord.
Respondents. That is not relevant.
Please.
The land counsel appearing for the respondent submits that when an order is passed and then a probate is granted, he has a remedy under
63, my lord.
263.
under 263, and the same shall be exercised before the very same court without exhausting the said remedy. He had come up before this court. In response, that this appeal is not maintainable. Lenatina Council had relied on section 299 and submits that still they can maintain an appeal against every order made by the district judge. The appeal lies to the court. It is a submission of the land council with the respondent that is in a case where the applicant is aggrieved by the said order, but that's not an option available to a non-applicant. And that is only under 263, he has to go before the very same court. It is submitted with the Lenin Senior Council that when they have approached for such a relief before the trial court, the said application is not entertained. As such, they are compelled to come before this court by filing this appeal. Next, having heard the counsels on either side, there is a material on record. It is a grievance of the appellant that a probate is issued in basing on the will executed by the grandfather in favor of the grandchildren. When the very same, in respect of the very same property, in a RFA or RSA?
RFA, my lord. RFA, my lord.
In RFA, this court has held that the daughter that is appellant herein is entitled for partition of the said properties. When the fathers of both the respondents are parties to the second in the partition proceedings, nothing has been stated, and now they have come up with this and they have obtained a probate. Without going into the merits of the matter, it is appropriate to look at section 263 of the Indian Succession Act. Extracted. The provision makes it very clear that a person who is agreed by a grant of probate on any of the grounds enumerated therein has to go before the very same court. The court cannot say that they will not entertain such an application. If it has to be by way of a recent order. And just like that, they cannot say that they'll not entertain such a petition. Hence, this appeal is disposed of, giving liberty to the appellant to pursue his remedies under section 263 of the Succession Act. Accordingly disposed of.
Please.
Apologies. One mention.
IA 1/3 of 2023 was filed seeking permission to prosecute allowed. IA 1 of 24 is filed to condone the delay of 554 days in filing. For the reasons stated, that is also allowed.
Apologies for my interruption.
Then-
In serial number 12, interim order need to be extended, my lords.
Serial number 12, interim order is there, extend. Yes, next.
Appearing for respondent, your lordship.
14, my lord, my client is agreeable for the,
For that.
yes, Avinash G.
What
Kamath.
they are saying. Yes. Let's-
Avinash G. Kamath.
May I make a submission, your lordship?
Oh.
Your lordship has granted visitation rights on this weekends, your lordship.
Give the order.
Mother as well as daughter were present before the court premises along with advocates, your lordship. The petitioner has not turned up, your lordship, for visitation.
I don't know, Melody.
Why your client coming to the court and not turning up when the order is passed?
I don't know, Melody, what has happened.
Tell him, if he
Yes.
continues on another occasion, we will say that
I
he's
don't
not
know, Melody.
interested
I
in
don't know
that.
whether.
Tell him that.
What has happened?
Which case you have given?
3871.
3871, give that docket. That you give. Order is passed in that, I think. Last time, in which case the order is passed? I think in
I'm
this
not-
docket, these orders do not reflect the order of, as per this. Yes, this is on 8/8/2024, the order. That must be. The petitioner father is permitted to exercise the visitation right in the trial court
Yes.
premises
Yes,
on
your lordship.
Saturday.
Yes.
They'll come up with some other name.
Yes, same.
On 8/8/2024, this court had passed an order wherein the court had observed about the submission of the counsel for the father that he has no confidence in the doctor, and they'll come up with some other name. And this court had permitted the father to exercise visitation between 3 PM to 5 PM on Saturday, 10/8/2024 at the court premises. This court has also directed that the counsels appearing for both the parties before the trial court shall be present. Today, when the matter came up, learned counsel for the petitioner father submits that the doctor which is suggested by the wife is also agreeable for them. And it is submitted that agreeable for them. Learned counsel appearing for the respondent mother submits that as per the orders passed by the court on 10/8/2024, they were present with the girl before the trial court, in the premises of the trial court, but the father has not turned up. Then counsel for the father submits that he has no instructions from the client. Considering the submission of both the parties, this court is passed the following order. Next, as directed by the court earlier, on all the Saturdays. But what court premises will be open?
I don't know, ma'am.
Yes, your lordship, it was open.
No, because
Least
not
if
it's
they
a
had-
mediation center, no?
Mediations.
It's not a mediation center. The
It's not a
premises they
mediation.
want to meet. In the court premises, on all Saturdays between 3 to 5, the father is permitted to meet the child and in the presence of the advocates appearing before the trial court, number one. Number two, the mother has
timings,
given the.
timing.
3 to 5. What is the name of the doctor?
Avinash G. Kamath.
Give the name.
Yes.
So and so
Give-
as accepted by both the parties, so and so, the
Yes,
father, mother and the daughter shall be present before the doctor. And the doctor, the doctor has to speak to all the three. And then basing on the requirement, if counseling is required to all the parties or to any of the parties, they shall, counseling shall be given and a report shall be placed before this court. Pose this matter on September 18th.
Date may be given. for-
18th. September 18th. Next, they shall appear before the doctor on which day? That is same day on a Saturday, we'll do it.
Yes,
On Saturday.
Yes, sir.
What is the coming?
Particular date may be given.
Saturday is 17th. This Saturday is 17th. On 17th.
Yes, sir.
They shall be present before the doctor on. at
Time
11
also may
o'clock,
be fixed.
11 o'clock.
Time 11.
11.
May I make one more submission, Your
Huh.
Lordship? In writ petition 1908,
Huh.
I have filed it for renewal of passport of daughter, Your Lordship. I'll submit the passport of mother, Your Lordship. The same may be permitted, Your Lordship.
Lord,
Because she is citizen of US, Your
no,
Lordship.
I have
For all
already
the
filed an application seeking for injunction not to take the child out of the
No,
jurisdiction.
no, let it be. No, that's what, last occasion he said.
Yes.
What will it is submitted that they will renew the passport and surrender it before the trial court. It's there, that's what on the last occasion. he has
Instead of
submitted.
child, mother's passport will be submitted, Your Lordship, because child is citizen of US, Your Lordship. For all the documentations, we require her passport.
My lord,
What
let
is this logic?
let the matter be deferred to that date, my lord.
No,
All
but
these
if it
matters.
has to be, renewed, it has to be renewed.
There is no
No,
date fixed for.
Please
renewal.
get instructions.
Sure. Yes.
We'll pass that order.
Yes, Your Lordship.
That that passport has to be surrendered after renewal. Get instructions.
Yes,
Only
sir.
that I'll add. If it is, our instructions are they will surrender, then we'll pass an order for
Yes.
pass over. You can tell the court. It's 1:30.
Serial number 15.
Yes.
Your Lordship, I appear for the KV to respondent. I pray for a week's accommodation to file objections. I have informed the learned counsel for the appeal.
Yes. 15 at the request of land counsel for the respondent, post this matter on 21st or 27th?
27.
27.
Grateful, Your
Number
Lordship.
16, Sneha Nagaraj.
Yes.
The respondents, my lords. This is an appeal that is arising out of an application under 39 Rule
Ready?
10. We are ready, my lords. We're led by senior counsel. We'll try our luck in the afternoon. Please, my lords.
Lordship, serial number 15, 21st, it may be had, Your Lordship.
21st?
21st, Your Lordship, 21st.
15, 21st. Yes.
Grateful, Your Lordship.
17,
Serial number 17, C. Shankar Reddy for appellant.
I am appearing for respondent number 2 for filing objection. A week time may be granted.
Lord, this is a matter where your lordship Lord was pleased to hear on 1st of August 2024. Lord, in the course of dictation, Lord, I pointed out
where
to
you
the
have not
court
filed an application.
that the one of the
No,
respondent was not
This-
served.
In this case, what are the objections? We'll only look at what is the order of the trial court, whether it is right or not. No objections are required. You can argue.
Next time, a week time may be.
Order,
granted.
Lord, has not been granted by the trial court.
We will have, don't ask for any further adjournments. We'll have it on 20th.
22nd. 22nd.
Post on 22nd. What is this bargain? You should
No.
have been ready by this time.
Correct.
22nd, post on 22nd at the request of land counsel, the respondent. No further time will be granted. Yes, 18.
Serial number 18, Venkatesh T.S. for appellant.
Coming of. Let it come. In the afternoon we'll take. 19.
19, Muralidhar.
The order application under 39 Rule 1 and 2 has been.
We'll hear it. I just want to see like, yes, 20. After lunch.
For the respondent,
Serial
your
number
lordship.
20,
Seeking an accommodation, we'll file the objection, your lordship.
Lord.
Last week we have entered up.
Let him say. Yes.
Lord, I am the appellant, my lord.
Hmm.
This is a dispute between the builder and the apartment.
No, he is asking for some accommodation. Is it
No,
okay?
I want to.
Yes, we will see in the afternoon. Yes, 21.
serial number 21, Dhananjay Kumar. General
Any stay in
Authority.
this?
My lord,
We'll hear it then.
please.
Yes, 22.
Serial number 22, Srivatsava.
Ready?
Ready.
We'll have it after lunch. Yes.
My lord, the serial number 7,
7.
which is fixed for next month, 2nd, court may kindly call for records, ma'am. Records.
In that matter, number.
At,
will know,
3
like, give that number.
Yes.
Registry is directed to call for the record in the arbitration matter.
Yes, ma'am.
I think it is required.
Yes,
Registry
ma'am.
is directed to call for the records by that date.
ಅವರು ಅದೇ ಅದ್ರೊಳಗಡೆ ಕಾಲ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗ್ತದಂತೆ ಮೇಡಮ್.
ನಂಬರ್ ಕೊಡ್ಲಾ?
89 ಪೋಸ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಅದು. ಅಲ್ಲ ಮೇಡಮ್ ಇದು ಒಂದ್ ನಿಮಿಷ.
MFA 5460, serial number 7.
TCR ಕಾಲ್ ಡ್ರಾಫ್ಟ್ ಕಳ್ಸ್ಬಿಟ್ಟಿದ್ದೀರಾ ಮೇಡಮ್? ಒಟ್ಟೋಗಿದೆ ಡ್ರಾಫ್ಟ್. ಹಾ ಏನ ಡಾಕ್ಟರ್ ಪಿನ್ ಮಾಡ್ಬೇಕು 50948 ಅಲ್ಲ.
ಮೇಡಮ್ 230 ಯಾವ್ದಾದ್ರು ಮೂವ್ ಮಾಡಿದಾರ?
ಚಂದ್ರನಾಥ್ ಅರಿಗ 33. ಆರ್ಡರ್ ಪಾಸ್ ಆದ್ಮೇಲೆ ಎಲ್ಲ ಹೊಟ್ಟೋಗಿರ್ತಾವ ಫೈಲ್ಸ್, ಮತ್ತೆ ಆರ್ಡರ್ ಸೈನು ಆಗ್ತಿರುತ್ತೆ.
ಮೇಡಮ್ 230 ಯಾವ್ದಾದ್ರು ಮೂವ್ ಮಾಡಿದಾರೆ?
230 ಯಾವ್ದು ಮೂವ್ ಆಗಿದೆ?
ಅದು ಇಲ್ಲ ಮೇಡಮ್.
What up, sir? What up, sir? Stop.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಕೋಟ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಮೇಡಮ್, ಏನಾರ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು 26.
36 ಇದೆ ಸರ್.
26 ಮೇಡಮ್ 26.
26 ಇದೆ.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
33 ಏನ್
Huh?
ಅನ್ಮ್ಯೂಟ್ ಆದ್ರೆ ಇಲ್ಲ ಮೇಡಮ್, ಅಲ್ಲ ಮೇಡಮ್. ಇವಾಗ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಕೇಳಿದ್ರು.
It will recognize otherwise, not mine.
ಅದು ಒಂದಿನಲ್ಲಿ ರೆಕಗ್ನೈಸ್ ಆರ್ ವಾಯ್ಸ್ ಎಲ್ಲ ಬಂತು. ಡಿಲೀಟ್ ಮಾಡಕ್ಕಾಗ.
Password.
My
Lord,
lord,
once- My lord, serial number 24, my lord. Petition, I have intimated the petitioner. One is filed by the petitioner, wife, my lord, another filed
I
by.
can
husband.
understand all that. Why are you making a mention now? Why have you not done it in the morning? It can't be done. Please wait. Yes,
Last over
My-
matter.
my lord, kind permission, my lords.
yes.
Serial number 14, my lords, has sort of one. So far as that passport issue is concerned, my lords, I will deposit mother's one because the child has got only ID card is a passport, my lords. That is what last time, my lords, I made a submission because she's a US born, my lords, citizenship. For everywhere identity card as a original, she has only passport, my lords. That is why, my lords, I said I'll deposit mother's. And there is an order of this honorable court. There is an order of this honorable court that she should not travel beyond India, my lords.
No. What is the difficulty now?
My lord, my.
Mother's passport is there. No,
My lord,
my
my-
daughter alone will be sent.
My application, my lord, seeking for injunction that is pending before this honorable court. Taking.
No,
child out of-
that day, when the argument was concluded, before passing that, passing out the matter for one reason, the court has already taken a view that once they deposit the passport, if mother's passport is deposited before the court, how the.
Child also, my lord, they may take it with the permission of the court.
No, child's every time is an ID card.
1 minute, that's the
Please.
only identity
My
card
lord,
she has.
with the notarized copy, it will be accepted. If they take the notarized.
When you are having any apprehension, there should be a basis for that.
My lord, she is a US citizen. They may
She'll
take
go
her-
on alone.
No, with the
Mother
mother.
will send her without she accompanying her. Why will she send? Because her passport is will say that her passport should be deposited before the court.
There is an injunction against mother and the child, your lordship.
That is there, already injunction is there.
Injunction is not there, man. That is
So
dismissed.
there is an
India
order.
not to
passed by
leave
the court.
India,
There is
my
an
lords.
order not to leave the.
India,
jurisdiction
not
of
to
the
leave
court.
India, my lords. There's an order by this
So how
honorable.
many precautions? First of all, under which provision this injunction is granted is the first question.
Not granted.
So no, even such an application, how is it maintainable in GNWC is one more thing. So what we will do is, let her, because for the renewal purpose and all, no, where is the passport?
With mother, my lords, with mother. That has to be renewed.
That is with the,
Mother.
Mother now. It got expired, my lords. Visa and both passport has got expired. They have to renew, my lord. That's why we filed an
so for that
application.
his consent is required.
That is why our application, which was not considered.
In the morning order, continuation, number 2. This is the one. Point number 4. It is submitted, it is submitted that the passport of the daughter, who is a US citizen, is already expired and it has to be renewed. Learned counsel for the respondent, that is learned counsel for the father submits that. If the passport is renewed, there is every likelihood that as the girl is a US citizen, she'll be taken out of the country. Learned counsel appearing for the mother submits that they'll deposit the mother's passport before the trial court. Considering the same, the mother shall, as submitted, the mother shall deposit the passport before the court. Then the father shall give his consent for renewal of the passport of the child.
Serial number 40, I am filing a memo for withdrawal, my lord,
Take that.
as a commercial appeal to be instituted. So by mistakenly it was posted. So I seek for withdrawal.
Already you have filed another appeal.
Yes, my lord.
Why have you filed another appeal when this appeal is there?
And my lord, it was to be like withdrawn before the total 39 itself. So there I was
They
not.
submitted the petitioner. The appellant wants to withdraw the appeal. A memo is filed in that regard stating that they have preferred another appeal.
Commercial appeal.
Accordingly, the memo is taken on record and dismissed as withdrawn. Yes, next.
Obliged. Thank you.
Passed over matter, serial number 4.
For the respond number, Lordship, for the appellant.
Yes.
And KBS.
We are filing a memo,
Hmm.
which was in terms of the settlement.
Hmm. What is the order impugned before this court?
My lord, the interim order has been granted in favor of the respond number 4. Their application for injunction has been rejected. Challenging the said order, they have approached this honorable court. In the meantime, there is a settlement agreement awarded between the appellant, respond number 1, and the respond number 4, tripartite agreement, whereunder the respond number 4 has agreed to pay 1 crore 50 lakhs towards the full and final settlement. And by virtue of this order dated 8/4/2024 by this honorable court, I was directed to pay 6%.
What is the consequence of this? Now the suit itself is going to be.
They have undertaken to withdraw all the cases. 5 cases are pending.
Your Lordship, in terms of the.
And you will file a separate memo before the trial.
For the trial, please.
Pass it on.
Have to return back the checks.
Hmm. They are all returned.
No, ma'am. Checks they have to return. It has been agreed that they would return the checks.
Your Lordship, we
What
are,
it says is, the appellant is hereby returning the following checks.
yes, Your Lordship, we are returning.
They have to return back.
Security checks.
Huh?
These were the surety checks that were given, Your Lordship. We are returning it to.
How many?
2 surety checks. For
Check number
1 crore and 50.
1 and 2. Two
Yes.
checks are given, one for 50 lakhs and other for 1 crore
Please.
is returned.
Please.
The appellant has received a sum of rupees 1,82,050, 1 crore 82,000, 82 lakhs 50,000. The sum of rupee 2,17,500 is paid in the name of so and so. Settlement arrived as to the appellant affirm and come the MOU dated entered into between the appellant and respondent stands cancelled. The name of phone and other concurrent. The present appeal is filed. Agreed with the orders passed in. Where is the order?
Case number 596/20.
Passed in IN number 1 in OS number 596 of 2020 dated 5th August 2023, whereby the trial court had dismissed an application filed with the plaintiff seeking interim injunction. During the pendency of the appeal before this court, it is submitted that the parties have entered into a settlement and they have filed a joint memo before this court. As per the joint memo, learned counsel for the appellant submits that he undertakes to withdraw the 4 cases pending and the details of the same is given. And it is also stated that the appellant is returning 2 checks.
2 surety checks.
2 surety checks number 56630 dated 12/11/2020 amounting to an amount of rupees 1 crore and another check number 56629 dated 17/10/2020 drawn in favor of ML Govindaraju Gowda amounting to rupees 50 lakhs. And the appellant has received a total sum of rupees 1,82,000, 1,82,50,000, and a sum of rupees 50 lakhs.
Your Lordship, that is inclusive.
That is the manner in which, yes, has received a total sum of rupees 1,82,50,000. And the respondent number 4 had paid an amount of rupees 2,17,000. That is also a form of it.
That's a part of,
Ah,
that is inclusive.
Yes. It is stated that by the appellant that in view of the MOU dated 12/8/2024 entered into between the appellant and respondent number 1 stands cancelled. And appellant has no claims whatsoever against the respondents. Accordingly, in the light of this, the request is made to dispose of the case as settled between, as the same is settled between the parties by agreement dated. What is this 8/10/2020 agreement?
No, there is a mutual agreement between the parties. In pursuance of that agreement only, we have made the payment.
So 2020, no, it is, it took 4 years for that.
As per that agreement.
As per the agreement dated 8/10/2020, the present application that is filed is agreed by an order granting interim injunction. Now, in the light of this memo filed before this court, the appeal is disposed of. In respect to the pending applications, both the parties shall file a application before the trial court accordingly disposed of. IA number so and so is filed to condone the delay of so and so. Same is recording the reasons stated in the accompanying affidavit, the same is allowed.
Cell number 16.
If the respondent
Yes,
matter will have to be heard.
I'm ready.
yes, yes.
This is an appeal that is arising out of an application under Order 39, Rule 10. The suit pertains to a dispute between a builder and the association comprising of all the owners. In that suit, what the claim that has been made is that there is a corpus fund that has been collected. Close to about 5 crores 91 lakhs has been collected by the respondent. That corpus fund has been retained by them to be handed over to the association. Now, what has happened is over the course of time between the agreement to sell that was entered into by all the owners and the sale deal, the nature of the usage of that corpus fund has changed. So therefore, what has happened is with respect to that corpus fund, the association today is before the trial court seeking that let this corpus fund be handed over to them. There are also a few other reliefs that are sought for with respect to cancellation of certain clauses of the sale deed, which pertain to this corpus fund itself. Specifically, this application pertains to the deposit of that entire corpus fund that has been collected by the respondent before the trial court. We are not even saying let it be released to us. We are saying let it be secured before the trial court for the simple reason that the association apprehends that this amount will be eroded because the entire discretion of utilization of the funds is with the respondent as of now. We do not know whether it has been used. In fact, the association does not even have clarity as to whether it has been used in the past or not.
What are the conditions in the sale deed?
I will just take your honors through the sale agreement first and then the sale deed.
No, before that, we'll just go to the order and then you can.
Please, kindly look at the order. The impugned order is at page 43.
I must also point out that some more documents which need to be filed. I think all the records of the trial court are not before your lordship.
The relevant records are here. In fact, the
handover documents are all not there.
There is only one handover deed that has been executed, which is not here. But in fact, the impugned order, my challenge is on the point of law itself. It is not even on the point of anything to do with the facts.
We'll see.
At that point of time, if this court feels that additional documents have to be filed,
please come to the order.
Page 43 is the impugned order.
Cancellation of the suit that is instituted is seeking cancellation of portion
Clause 13 of the sale deed, which pertains to the corpus fund. Kindly come to page 51. 51 is the effective portion of the findings of the trial court. Para 11. Para 11 starts with extraction of Order 39, Rule 10. Thereafter, the trial court, I will just summarize the impugned order before I just read it out. The requirements under Order 39, Rule 10 require that first there has to be an amount or the suit must pertain to money or something that is capable of delivery.
In this case, it pertains to a corpus fund, so therefore it is capable of being delivered. The second is any party thereby admits that he holds such money or other things as a trustee for another party. This is where there is some differentiation in terms of what I have argued and what my learned senior has argued. My learned senior argues that there is a party in the context of the present suit, an apex association, who is not a party to the present suit. And that is what the finding of the trial court is as well.
This is small order. Please read and then you can make your
Please, I will read para 11.
Yes.
Besides, it is also worth to note whether the court can direct the defendant by exercising its power under Order 39 Rule 10 CPC to deposit the amount as sought for by the plaintiffs in this application. Order 39 Rule 10 CPC reads thus: deposit of money, etc. in court. Where the subject matter of a suit is money or some other thing capable of delivery, and any party thereto admits that he holds such money or other things as a trustee for another party, or that it belongs or is due to another party, the court may order the
plaintiff. Who is the plaintiff?
I am the plaintiff. The plaintiff, so there are multiple plaintiffs. The first plaintiff is the association. There are other individual owners also who've been arrayed as plaintiffs.
One Bangalore West.
One Bangalore West is the association. There are other plaintiffs who are also
individuals. What is this apex association?
That is where the differentiation occurs. So in my agreement to sell, there was an association under the Apartment Ownership Act that was supposed to be created. There was a confederation of associations that was to be created for maintaining the common areas. So just in terms of how the development has happened, the development has 9 towers, out of which 2 towers are still under construction. Apart from that, there is one other luxury tower, which is also, so technically there are 10 developments. And all of these were originally contemplated to have separate associations. Now there are some common facilities and common areas that fall to all of these associations. So that confederation was supposed to maintain that common areas which fell to the share of all of these associations. That is as per my agreement to sell. That confederation of associations later transformed into an apex association under the sale deed. Now, the sale deed is what is being challenged by me in the suit as of now, because I am saying that as per the agreement to sell, I was supposed to receive this corpus. At the time of the sale deed.
No, according to you, the association, that is the plaintiff association, is not the one which is going to maintain the premises or whatever. The maintenance is not to the association, it is to the apex association.
No, my case is that there are 2 parts in the entire development. There is a large component which is being maintained by me as the plaintiff association. There are some small common areas which fall to the share of the apex association.
Please come to that agreement.
Kindly look at the sale deed itself. The sale deed, your lordship will find at page 130. This is I've produced one of the sale deeds. In fact, in the trial court, we had produced the sale deeds of all of the plaintiffs. They're all identical, so I did not want to burden the court before this court.
Yes.
Kindly come to page 141. This is the scheme in which the apex association has been formed. 141 clause 6.6, which says seller scheme. 6.2. The scheme envisages the formation of individual apartments.
6.1 you read.
6.1. The seller scheme consists of developing the residential apartment towers, commercial buildings, or a combination thereof on the Schedule A property in a phased manner development, of which is currently estimated to be completed in or around 2024, or on a later date at the discretion of the seller, and selling, transferring the apartment units therein on ownership basis or otherwise to purchasers, transferees, along with proportionate share in land as more particularly described hereinafter. 6.2. The scheme envisages the formation of individual apartment unit owners associations for each of precinct 1, comprising of precincts 1A, 1B, 1C, precinct 2, and precinct 3 of the Schedule A property, to manage the internal tower areas of the tower wings comprised in each precinct of the Schedule A property. So under this, please.
Complete.
The said owners association of each of the aforesaid precincts will be formed after the completion of handover of the apartments and registration of the sale deeds related thereto in each of the towers. The seller scheme also envisages the formation of an apex body of the owners associations after completion of the entire project. The apex association will, upon completion of the development of Schedule A property and handing over of the same by the seller to the apex association, be responsible for the management and administration of the precinct 1 external areas and Schedule A property common areas. So this is the separation that is created.
No. When was this agreement? Sale deed is.
The sale deeds have all started from 2016 onwards. There are multiple sale deeds. There are 472 apartments, so there are
No,
they've started from
the
2016.
entire A and B schedule constructions are over, development is.
There is one part of it which is still under construction. 2 towers are still under construction.
Unless and until that everything is completed, this apex body.
Apex body will not be formed. Today it is not in existence. There is no dispute with respect to that. But what has happened is the precinct 1A and 1B and 1C. So they comprise of 5.
No. It is not that you're telling it the other way. No, till it is completely handed over, till such time this apex association will be taking care of the management.
No. It is the other way around, your lordship.
Let's read it.
What happens is
From the middle, please read.
the seller's scheme also envisages the formation of an apex body of owners associations after completion of the entire project. So what the builder is contemplated is there may be individual associations that are formed as and when the towers are completed. But the entire common area, so precinct 1 common areas and the schedule A common areas that are to be maintained will be handed over to the apex association after the entire development is complete, which is not the case today.
No, it is not done.
It is not complete, so the apex association does not exist. But what has happened is, so my association comprises of 5 towers, which is precinct 1A and 1B as per this clause. Now, the management of the entire assets and the equipment that is existing inside these 5 towers has been handed over to me. That is again not in dispute. There was a handing over deed which my learned senior referenced. That is an admitted document. There is no dispute with respect to that. They have been handed over to me for my usage and for my maintenance. Now, what happens is this corpus fund was collected with the purpose of replacing capital assets within the entire association.
Where do you get that corpus?
Please come to clause 13, which is at page 166. 166.
Yes.
At the bottom of the page, clause 13. The purchaser shall, at the time of taking possession of Schedule C property from the seller, pay an agreed sum per square feet of super built-up area of the Schedule C property as corpus fund, which will be utilized for major maintenance works in the towers, common areas, roads, amenities, and other facilities in the Schedule A property. And unspent amounts will be transferred to the seller to the Apex Association, simultaneously with handing over of responsibilities to Apex Association of maintaining the common areas. This is the crux of what my challenge arises out of as well.
You want this to be set aside?
I want only the part which says the handing over will be done to the Apex Association to be set aside. Because in comparison, your lordship may kindly look at my agreement.
No. As per this agreement, till this Apex Association is formed, who will maintain the premises and from what amounts?
That is the dichotomy that I'm bringing forward. Today, what has happened is, originally when this clause was executed, the developer was maintaining everything and the developer was holding on to the corpus. There was no issue as far as that was concerned.
Till what time?
Till 2021. Till 2021 is when my association was formed, and simultaneously there was a handover deed that was executed. Under the handover deed, what has happened is the responsibility of maintaining these assets has been passed on to me without passing on the corpus that was utilized for replacement of these assets. So I am only saying that, look, I have a cost because this development started in 2012.
You will be maintaining the apartment by collecting the monthly
I collect
maintenance.
additional maintenance from all of my residents today. Because I do not have the corpus fund at my disposal, what I have been doing is I have been collecting an additional sinking fund from all the residents so that I can meet my capital expenditures as well. Because the development started in 2012. Today, we are already at a 12-year timeline in terms of some of the assets that exist today. So there are several capital assets which require replacement. So we have been collecting additional funds. But our question is, when this fund exists today, when almost 6 crores has been collected by the developer for this intended purpose, we are not able to access it. And we understand that is the subject matter of the suit. So all we are asking for today is let it be deposited before court. So that is as far as the facts go. If your lordship intends, I will take your lordship back to the impugned order, because there are several findings which are in fact contrary to law itself.
Please come.
In the impugned order, kindly come to page 51. We were just reading part of page 51 and 52. So the case is that there is a specific provision in the Karnataka Apartment Ownership Flats Act, 1972, which says that a separate account has to be maintained for all the funds that are collected by the builder. In the act, the reference used is promoter. But as far as that clause is concerned, that clause clearly says that the builder will act as a custodian for that fund. Everything has to be maintained in a separate account and has to be dispersed for the purpose for which it was collected. That is the provision of the COFA.
What is the case of the defendant?
The respondent's case today is threefold. One, they say that the Apex Association is the intended recipient of that corpus fund. Because the Apex Association is not a party to the suit, 39 Rule 10 does not apply. Number one. Number two, they say that the sale deed supersedes any other previous agreement that had been executed, because my reliance is also placed on the agreement to sell. So they say that the sale deed supersedes the agreement to sell, and therefore there cannot be a reliance placed on the agreement to sell. The third is that there is no admission. In fact, that was not even vehemently argued as far as my senior was concerned. That is something that the learned trial court finds categorically to say there was no admission, despite the fact that there are documents where they admit that they are custodians of the corpus fund. The third.
Come to that objections. Where are the objections?
Please. Page 62 is their statement of objections. Page 63, your lordship will find their preliminary objections. The first one is to say that the party intended under Order 39 Rule 10 is not a party to the suit, because the party here pertains to or refers to the Apex Association and not to my association.
Where is the plaint?
Plaint is at page 72.
73.
72. 72 is the index, 73 it starts.
It is 73 is not the plaint. It is their objection starts at page 62.
Correct.
Plaint.
Plaint is at page 72. Their objections is only, it's still 71. 72 onwards is the plaint that I have filed.
Objections have come first.
Because it is the application
Objections have come
objections
first
thereafter
and then
the
the
plaint.
No, what did you say in the plaint? What is the necessity for seeking that order?
The necessity is twofold. One is I have no clarity with respect to the manner in which the corpus fund is
When
being
did you, the sale deeds are from the year 2016?
2016.
No, when in year 2016, when you have entered into when a registered sale deed is executed, no, in suit is of 2024.
So it is 20.
So there must have been something there should be, because this clause of corpus fund is is there from 2016. So suddenly now you want injunction in 2024. What is that?
I will explain. So what has happened?
What have you stated first? That
No,
we
no,
will see.
I will take your lordships through what has happened as well. I will point out the relevant amendments. So what has happened is in 2016, the sale deeds began getting executed. Till 2021, the association was not formed at all. Now, the reason for all of this to have started and the reason for having made this claim today is because in 2021, two things happened. One, the association formed. And the second is the handover of all of these assets was made in my favor, in the association's favor. That were two incidents that occurred. The third incident that has occurred subsequently on several occasions is that every time we have asked access to these corpus fund, because at the end of the day, the understanding was that, yes, you are holding the corpus fund as a custodian. But as and when I require access to that corpus fund, you will provide me access, because that was the intended purpose anyway. It was intended to meet my capital expenditures in terms of equipment or any other capital expenditure.
That is a sale deed. Sale deed and all the terms and conditions of this agreement or whatever it is, you are aware of it and you have accepted it. That unless and until that Apex Association is formed, till such time the builder will not transfer the corpus amount to the association.
Your lordships, I understand
Now the court has to, by virtue of this the relief that you are seeking in this suit, unless and until the court says that such and such clause is bad, you are not entitled for any relief. No, for seeking an interim relief, now what is the specific reason? These are all the reasons for your main relief.
Please.
What are the specific reason for an interim relief?
Your lordships, under Order 39, Rule 10, the only thing that I need to establish as an applicant is that one, the money is held on my behalf by another as a custodian or on my behalf as part one. The second is there is an admission to that effect. If these two requirements are met, there are several judgments which say the quantum of what is sought to be deposited or what is directed to be deposited is immaterial. If there is an admission and there is an admission to say that you're holding it.
First of all, there should be a reason for the court to pass such an order.
No, the reason today is my apprehension. There are two reasons.
What are the reasons?
Your lordship may kindly look. I will explain. So what has happened is kindly look
at not the submissions. First you point out from the.
Please kindly look at page 115.
Yes.
Which is the corpus clause in my agreement to sell. I will just point out what the change has happened, because that change is necessary for this court to understand.
That is orally you are submitting. I'm asking you, where is the IA and what is the need for such an agreement?
The application is at page 55.
Yes, let's see that.
Please.
Please point out the particular paragraph.
Paragraph 5 at page 57.
Yes.
However, at the time of execution of the sale deeds in favor of the purchasers, the defendant unilaterally changed the terms of the sale agreements after having received significant portions of the amounts under the said sale agreements and insisted the amounts would be handed over to an Apex Association. While the said modification of the sale deeds was objected to, the dominant position of the defendant in already having received large sums monies from each of the purchasers forced and constrained the purchasers to execute the sale deeds as demanded by the defendant. However, even under the sale deeds, the defendant continued to affirm that the corpus fund was held in its custody to be handed over to the Apex Association that was sought to be formed by it after completion of the entire development of the Schedule A property. Next paragraph. I state that contrary to the subsequent change in the intentions of the defendant, the representatives of the defendant had represented to purchasers of towers 1 to 5 that it was collecting the corpus fund on behalf of the plaintiff number 1 association. The same can be observed in the email communication dated 10/11/2012, wherein the defendant had clarified that the funds collected on behalf of plaintiff number 1 association will be kept as a fixed deposit and will be handed over to the plaintiff number 1 association when formed. The representative of the defendant further went to say that even the interest accrued on the corpus fund deposited in bank would also be handed over to the plaintiff number 1 association for utilization by it for some unforeseen capital expenditure.
Yes, one. No, what is the difficulty to at least share? What is the corpus fund that is lying?
This is not only for them. It is not, I mean, this is not a.
Only them. Who are there? Only one block?
They are one block, they one precinct of 5 blocks.
5 towers.
5 towers, and not there are the first towers which were built. So how it worked was an association is created for them. Then not another association is created for precinct 2, and then there's a third precinct. Now all of this is under construction, and some of them are under certain associations. Now in a case of this kind, where certain precincts are to be managed by one association, another to be managed by a second, and the third to be managed by the third, there is one which has to manage for everybody.
That is the Apex Association.
Which is the Apex Association. So structurally, how it works, my lord, is this corpus fund should be in the hands of an association which will not utilize it only for itself, because it is comprised of members from all associations who come and form the Apex Association. So the ability of them to manage the funds for the entire development in this entire extent of land is in some way holistic, so that they can then manage it. So the structure of the entire method by which it is done is to ensure that not one association takes off the money. Tomorrow what happens, my lord, is this association got 5, let's assume takes 2 crores out of the 5 crores and says we'll use it for ours. But if there's a larger cost required for the entire
You
area.
don't have to, you don't know right now, even if
Yes.
you don't have to transfer, give the corpus to anyone till the association is formed. No, everybody, the members of the association has every right to know what is the corpus that is collected and what is it
Yes, yes.
lying.
There's
That means
no
the affairs
dispute.
could have been very, very
There's no
transparent.
dispute on that, Lord. There's no issue on that.
Transfer it.
I'm not
At least
transferring it.
one should know what is it.
Yes, yes, that money is there in a separate bank account. There's no difficulty insofar as the money is concerned.
That's
No
what
money.
he was asking in this.
No,
It
no,
was not
I'll tell
clear.
you Lordship, what is being done. Now it is a question of some kind of a power struggle. It is nothing more. The application is filed under Order 39, Rule 10. Can I request now look at Order 39, Rule 10?
It's extracted in the order.
Yes, Lord.
Yes,
Page 51.
yes.
Deposit of money, etc. in court, where the subject matter of a suit is money or some other thing capable of delivery, and any party thereto admits that he holds such money or other thing as a trustee for another party. The question is, who is this party? It can't be a situation, otherwise every suit will become a suit where I can recover money from someone else. It has to be a party to the proceeding. Therefore, if there are 3 parties to a suit and one of the parties admits that I'm holding this money in trust of party number 2, party number 1 can say, because we all are, or the plaintiff can say, since all of us are entitled to the money, you deposit it in court, let the court decide as to who the money should go to. The argument many times raised is that party does not mean a party to the suit, it could be any person. But most high courts have consistently taken the view that a party is a party to the suit. Therefore, if there is an Apex Association, let us say tomorrow, an Apex Association is formed, Apex Association becomes defendant number 2 in the suit. And I say, yes, I'm holding this money for the Apex Association. Then the plaintiff can say, well, let us not get into the argument who it should go to. Let the money be deposited in court. Let the court decide whether it should go to Apex Association or to me. So it is only in one unique situation. And of course, thanks to my learned friend, I saw the provision for the first time in my life. I had never seen this before, Malone. So when I saw this provision, we did some research, Malone, because the language is slightly different. But it uses the expression party specifically. When your lordships compares it, one of the provisions your lordships can compare it with this, Order 39, Rule 2A. Rule 2A uses the expression person. Especially when it comes to contempt, it is not just a party to the proceeding, but every person who has knowledge of the order who becomes responsible for compliance. So the law and the language uses, a party is a party to the proceeding, but a person may be a person outside the proceeding itself. And therefore, the question was one of jurisdiction first, which we pointed out to the court saying that if you have to exercise power in Order 39, Rule 10, then you must necessarily have the jurisdictional requirements to be satisfied. Namely, first, that all the parties who I may not admit, I don't dispute anything. I say, yes, this money is with me. This money has to be given to the Apex Association. And in the structure, and this is not just their sale deed. Now, your lordships will remember that every other sale deed for every other precinct has the same clause. Now, another set of people may come and say, how do you hand over to someone or how do you show it to anyone else? I'm also entitled to the benefit of the money. Now, what is their prayer? Cancel that term in the sale deed. Respectfully, my lord, a term in the sale deed can't be cancelled because a sale deed is a concluded contract. It is not an agreement to sell, which is an executory contract where something has to be done, where someone can challenge it.
No, why the defendant is making it so complicated? Just could have told them what is, when they're, simply you cannot hand over that.
I can't hand
corpus
it over.
Till such apex association is formed. At least what is right from 2016, the sale deeds are, and people, you have given possession in 2021, we are in 2024. So this is a corpus from
So many-
whatever A1.
Yes, I can place it before the
A2,
court.
A3.
There's no
That's the
difficulty.
court.
There's no difficulty. I can
All
do
I
it.
have asked-
Now, they're
I-
not asking me where the money is. They are saying you deposit it in court. That I can't do.
No, corpus, for example, all these people are in which block?
Towers 1 to 5. They're called towers 1 to 5. They don't have block numbers. They are
That's
called
what, towers 1 to 5.
1, 2, 3,
All
4.
of them are before the court.
All of them are before. All of them are before the
Beauty of
court.
it. No, the association is before the court. How does an association challenge a sale deed, which is a sale deed with respect to one particular individual?
No, I filed an application for
Minute, one
representative
minute.
capacity.
There is like, no, all of them are before this court, except that association which is not formed.
Apex
No,
association. is
no,
not.
no, my lord.
Hmm.
All the parties not before the court.
He says
Sir,
so.
I have filed an application.
No, not that. If there are, my lord, over 600 apartments,
Hmm.
which means strictly, if he has to have a declaration.
No, there are 5 towers. Each tower is having an association.
No, 5 towers is one association.
That's what it is, the entire.
5 towers is called one precinct,
Hmm.
and therefore, because my lord, it is like say
Oh,
group.
that is, there are like that another 4.
At that there are
4
3
more towers.
4 more
There are 4
towers.
more towers.
So this 1, 2, 3, 4, 5 towers are, people, the owners are before the court.
I don't.
That association. Representing them.
Yeah.
So, as far as they are concerned, you must be, that corpus is like, it won't change by basing on this and that. There would be some amount.
My lord, corpus is for the entire building,
Their contribution.
No, their contribution is recognizable. In that, the contribution is recognizable, but it is not allocable. The contribution.
Allocate, but
No.
tell them what is it, what is happening.
That I can point. I'll give it to your lordship itself. There's no difficulty. I can place it before the court as to whether there's money, how much money has been collected, and where it is. I can place it. There's no difficulty.
No. Tell the court, let there be a application before the court or an affidavit before the court stating that for all these 1, 2, 3, 4, that what is called present one.
Present one.
Present one. This is the corpus lying with us.
That we have already told them, my lord.
Where did you tell that?
Not in the proceedings. In the
That's
meetings.
what the cases that you're not telling.
In fact, your lordship.
That's not the objection. If you look at their IA, that's
Yes,
why.
yes.
That's what they have stated.
No, please see the prayer.
I have no clarity. In fact,
One second. Sally.
One thing, this
Give me one.
is such a simple issue. Let's not complicate it.
No.
Please come up.
Yes.
With an affidavit saying that these are the blocks. As far as these blocks are concerned, we have collected this corpus fund. And this is what is lying with us.
Yes.
Let there be an affidavit.
Very good.
When
But
we
can
file.
I only show your lordship the prayer?
Where?
Page 55.
Prayer of this injunction petition.
My
The
application.
application under order 39 root 10.
30, yes.
There is
Page number 50?
55. Honorable court may be pleased to direct the defendant to deposit the entire corpus fund collected on behalf of the members of plaintiff number 1, being the plaintiff and other apartment owners in towers 1 to 5, in the custody of the defendant, which it holds as a trustee with this honorable court. Now the prayer is that if he had said simply disclose where it is, I would disclose it. No difficulty at all. It is not as if we are trying to take away someone's money.
Disclose it.
Lordship may have it.
You have to understand.
Let them disclose that. I have no difficulty because our fight has always been that.
You have no difficulty because beyond that you will not get any order.
I understand. Let the disclosure. In fact, my learned senior mentioned that they've also maintained it in a separate bank account. Let them give the details of the bank account. Let it be a full disclosure.
I'll place it on record.
What is the amount? Where is it lying? To that extent you indicate, we'll dispose of it on that.
Yes.
When?
Lordship may have it next week. I'll
Yes.
file.
Pose this matter on 21st August, 20th August. 20th? 20th August, by the time the respondent, defendant shall file an affidavit before the court with regard to the plaintiff's association and the 5 blocks, how much is the corpus that is lying with them and it is lying in which bank?
Bank's account details, not this.
Details.
Because if they say it
Bank
is maintained in SBI, it is not really helpful to me. That is the reason.
Yes.
All details of the account may be fine.
All the details.
Please.
Till number 17 urgent, 18. Venkatesh TS.
Appellant in this case, your lordship.
Which is 18.
In the previous date, your lordship has instructed me to serve the copy on the counsel appearing for the trial court.
Yeah.
I have served and filed the memo to that effect, your lordship. I filed the memo also. They're intentionally dragging the proceedings, your lordship. Your lordship kindly appreciate. IA was filed in the year 2022. At the 39.
What is the name of the council?
Sorry, my colleague. Sorry, your lordship. My colleagues told that they have been served. I have placed a memo also before this honorable court, your lordship.
And summons is herewith produced.
Yes, your lordship.
No, the difficulty is
Yes, your lordship.
unless and until we know what
Yeah,
is the
yeah,
name
it
of
is
the.
in the.
No, that from that we can't understand what is the name. Please file a memo to that and we'll print their name in the cause list and then we'll hear it. Tomorrow?
Tomorrow.
Was this matter tomorrow at the request of non-counsel for the appellant? Yes, next.
I'll file memo.
Yes, you can file.
Cell number 19.
The appellant,
Yes.
the IA number 1 under 39, 1 and 2 filed by the plaintiff has been allowed, my lord.
It's been allowed.
Allowed.
What is the suit for?
The suit for declaration and the plaintiffs being utter strangers, they mutated in their names and they obtained kata, which has been challenged before the assistant commissioner and
Kata is of which year?
kata is my kata in the name of the father of the appellant in
Defendant.
the year 1953. And
It continued till when?
They mutated, which has been challenged before the competent authority, allowed, and it was retransferred in the name of the appellants. Subsequently, they filed suit for declaration.
Which year is that?
Which one, madam?
When the kata is again rechanged into your name?
Very recent, in the year 2000.
When was it changed to the name of the defendant? I mean, the plaintiff?
2023 one.
For a brief period of 1 year, it is in their name.
Yeah, please, 23 only.
Please come to the,
Subsequently, my lord.
please come to the plaint.
Relevant para, I'll read. Observation of the court.
No, we'll go to the plaint first.
Plaint.
Where is it?
Plaint is at page number 34. Their cause of action. Cause of action. At page number 40. Cause of action for the above suit arose on 19/10/2022, being the date on which the defendant number 15 colluding with the one to attempted to interfere. That is the cause of action which they have stated.
No, there is no relation between the plaintiff and the defendant.
They're far relatives, not close relatives.
They speak about partition.
Nothing, no partition, nothing. No partition. And my defense, my lord, my case is that
1 minute, 1 minute.
it is their case that they entered into one partition in respect of suit scheduled property, which is not at all belongs to them. And trial court has observed both the case of plaintiff.
So the whole basis is that 13/12/2006 partition date.
No. That they are claiming that
According to them.
They divided this property among themselves and got mutated, which has been challenged before competent.
Come to your written states.
Please. It is at page number 50, my lord. The case of the defendant number 1 to 14. Here 15, 16 and 17, which are the relevant paras. It is submitted that with regard to the said adoption, Muniga alias Muniappa Kavarappa is executed, registered adoption deed in favor of Muniga alias Muniappa. He is the father of the appellants. He got this, he has been adopted by one Dodkaverappa, and subsequently he has executed sale deed in favor of the father of the appellants. Based on the sale deed, my lord, he mutated his name in the revenue records. And thereafter, these people are in possession and enjoyment of the property, which is admitted by the trial court in the observation that originally Muniga has been adopted by one Dod Kaverappa, and he has the next day he has executed sale deed in favor of his adopted son. And after the death of adopted son, the appellants have mutated their name and they were in possession. All these facts have been admitted by the trial judge. At para 12 of the order, my lord. I'll just read para 12 of the order at page number 29. Trial court has discussed both the cases of the plaintiff as well as defendants, which is there at page number 29, which is the impugned order. Trial court clearly admitted the case of the defendants, which is
So the Khata is not of for 2024. It is of the year 1994.
2006, my lord. My lord,
Come to,
kindly page number 29,
no,
impugned.
I am looking at the written statement. Please come to page number 56.
56. 56.
That 55 from the last line, you please read.
Yes, my lord. This is the Kata. He has
Of the year
based
you're
on the said information, he has managed to obtain.
1994 to 1995.
Please, my lord, please.
So that is the Khata is in favor of the plaintiff right from 1994.
But in the real, they said.
That's what from your
very much alive
written
and he was-
statement only.
Please, please.
Basing on that, they have executed a registered sale deed on 22/9/2003. There is another sale deed thereafter from 1994 to 95 to 22/9/2003. Thereafter, this
This is-
partition deed has come.
Yeah, this is in respect of different, this is not the subject matter of this.
Hmm.
This property which is executed in favor of Viresh is not the subject matter.
Hmm.
This is not our property. This is not the social property, please.
Then why were you telling all this in
Because
your written statement?
the legal heirs of Munivenkatappa, it is, they acquired the different property in the very same survey number.
It's not that. You are saying that, again, para number 26. You
Please,
refer to
it is-
22/9/2003 document. The same document, which is in connection with the earlier paragraphs. So there are so many documents prior to this. Right
But
from
my lord, absolutely,
1994.
they do not have any document, title document to have Kata, my lord. That is the reason we have approached competent court, my lord. Competent court has set aside their name and it has been re-entered in the name of the appellants, who are the defendants before this trial court. And my lord, kindly impugned order at page number 12. Page number 12. Trial court, my lord, has discussed about the case of the plaintiff as well as defendants at page number 29 of the impugned order. Absolutely, they do not have source of title to have injunction. They have not produced any document to show that originally this property belongs to them, except the mutation which has been challenged and competent.
You sought for a counterclaim.
Yes, please.
What is the counterclaim?
Counterclaim. To allow the counterclaim, one to in respect of the written statement property and to set aside the registered partition based on which they got mutated. That is 13/12/2006 family members in respect of the social property, written is sham, collusive and fraudulent. My lord, based on this fraudulent document, by including the property of the appellant, they got entered into one partition deed and they mutated. That has been challenged and it has been set aside. They do not have any right to include the property of the appellants in the partition deed, my lord. Now, even trial judge, my lord, has discussed that they have not furnished any document to show that they have title on the suitable property. On the other hand, the appellants have produced adoption deed as well as sale deed in the name of Muniga. That the original this
So
property.
what did the court say?
That page number 29 at para number 12. Madam.
Until the suit scheduled property should be preserved as it is by restraining both parties from alienating the suit scheduled property pending disposal of the suit. That's one order. You cannot be aggrieved by this.
My lord, now after passing this order, they are interfering with my position with this order.
Both parties as well as defendant shall be restrained from alienating
But
the
absolutely,
property.
my lord, they have not
Defendants
furnished
are
any
permitted
document to
alienate
show
the
that.
suit scheduled property pending disposal of the suit. It will lead to multiplicity. Hence, the plaintiff has made out a prima facie case. The balance is so and so, and the plaintiff will suffer it so and so.
Absolutely, they have not placed any material to show that this property
Now,
belongs.
even according to you, till 2023, the revenue records are in their favor till you file a petition. Once that revenue records were mutated in your name, then he has filed a suit. Right from 1994 till 2022, the entries are continuing in their name. Prima facie, they could show their possession.
But they do not have any title, my lord. That is very clear in trial.
No, this is injunction is not about title. Injunction is
Okay.
about possession.
Please.
If they do not have title, court will decide it in the
Early
eventually.
disposal may be ordered,
Huh?
my lord. Because now with the help of this,
And that's what,
any order for the
what is early disposal, which year is the suit?
But my lord, now,
2023, that can't be an order. There are so many cases pending. Why please come. Agreed with orders passed in.
at least any early disposal, my lord, 6 months or 1 year, 1 year maximum. 1 year.
Cannot grant.
Otherwise, they'll misuse this interim order and 1 year, my lord, within 1 year.
That's what happens in every suit. There can't be a direction of that nature. I agreed with the orders passed in I number 1 in OS number 16 of 2023, dated 16th April 2024. The defendant is before this court. The respondent herein, who is the plaintiff in the suit, had filed a suit seeking declaration and injunction in respect of the suit scheduled property. Along with that, he has filed an application, that's I number 1, seeking an order of temporary injunction, restraining the defendants 1 to 14 from alienating or creating any kind of charge over the suit scheduled property pending disposal of the suit. The defendant had filed his written statement and also filed a counterclaim to declare that the registered partition deed executed partition deed of the year 2006 is not binding on the defendant. According to the plaintiff, he has been in possession of the property and right from 1994 till 2022, the same is questioned by the defendant.
Not possession, not to alienate, not regard.
Till 2024, 2022, till an application is filed by the defendant before the authorities, the mutation in his name is set aside. As per the revenue records, his name finds place. According to the defendant, there are no documents to show the ownership except the said partition deed. The trial court, while allowing an application, that is I number 1, restraining the defendant from alienating the property, the court has observed that Both the parties are claiming their title to the property unless and until the suit itself is disposed of, that the court cannot give a finding. Both the parties, no third party rights shall be created. If the third party rights are created, it would lead to multiplicity of proceedings. Hence, the court has observed that the plaintiff has made out a prima facie case for grant of temporary injunction, and the balance of convenience is in favor of the plaintiff, and accordingly granted a temporary injunction restraining the defendants from alienating or creating any kind of charge over the suit scheduled property till disposal of the suit. Learned counsel appearing for the appellant submits that under the guise of this order, the defendants or the plaintiff is interfering with the defendant's position, and he submits that when they have no right and title to the property and there no documents are filed, the court ought not to have granted such an order, injuncting the defendant from alienating the property. He also submits that there shall be a direction to the trial court to dispose of the matter as expeditiously as possible. Next, having heard the learned counsel for the appellant peruse entire material on record. The plaintiff has filed a suit for declaration in that the defendant had sought for a counterclaim. Looking at the revenue entries and the change of entries, there is a serious dispute with regard to the title between the parties. That can be decided only after the full-fledged trial. The trial court had rightly granted injunction, as if there is no such injunction restraining the defendant from alienating the property, it would unnecessarily create the third-party rights and also gives rise to multiplicity of proceedings. In that view of the matter, this court is of the considered opinion that the trial court had rightly considered the case of the parties and rightly granted injunction restraining the defendant from alienating the property. Coming to the request of the learned counsel for a speedy disposal, as this is a suit of 2023, there are other pending suits. There cannot be a direction to the trial court to hear this matter out of the way. And on that ground also, there are the said request also cannot be considered accordingly. The MFA is dismissed.
Cell number
Yes.
20. Arvind Babu J for appellant. Tina.
When we need a short accommodation, we'll file our objections.
Why the objections are required? He's telling
Your
something
Lordship,
which is.
Your Lordship, the trial court has passed the impute order based on several documents produced by us. Perusal of that
When
documents
did
is
this matter came up earlier? This coming up for the first time?
No, my lord, on 31st of July,
after serving the notice to us, it has come up for the first time. Your Lord.
For the first time it's coming. What is the urgency?
my lord, the appellants have been
When
directly,
was the suit filed?
this was filed in 2023, my lord.
When was
And-
the IA filed? When was the order in the IA?
4th of April 2024, my lord. The 2024, when the order was filed, my lord,
We'll give him a short time. Post this matter on 20th of August.
my lord,
At the request of learned counsel for the
interim-
respondent, no further adjournment will be granted.
interim, this may, because 20th, the date is coming up for, in the lower court also. my lord.
Matter is
How is it
posted for,
concerned with that?
Because they are proceeding with this, because this matter is not concluded.
No, interim injunction. For
The
the other
interim
things,
injunction,
for
but
other
it-
things, why it should be stalled?
Because, my lord, the first thing which I am addressing is there were certain judgments which were cited. In the order, it is also said, yes, these judgments were given, but there is no discussion, deliberations.
We will see. Yes, both the parties are here. No adjournment, no interim order. We'll pass a final order.
21. Dhananjay Kumar.
Yes.
Appearing for appellants.
Yes. What is the suit for?
Suit for partition, my lord.
You're the plaintiff?
Yes, my lord.
What is IA?
My lord, I number 5, which was allowed on 23/11/2023.
What is IA?
IA for temporary injunction, my lord. It was allowed vacating our temporary injunction, which was allowed to us on the prior date, my lord.
What is that? Not to alienate?
No, not to trespass. The IA which was allowed on our behalf was not to alienate the property, my lord. Subsequently, the alienation was done, and the respondent number 11 and 12, who were then impleaded in the OS suit, have filed this IA number 5, and it was allowed vacating our IA, my lord.
Let's see that. Come to the order.
Yes, ma'am. My lord, we filed an OS suit in OS suit 148 of 22 for suit for partition, my lord. And in the same suit, we filed an application under Order 39, Rule 1 and 2 for not to alienate the property. And the same was allowed on 18/12/2022, my lord. Further, it came to our notice that the defendant number 5 in the said OS suit has alienated the property. That is, he has sold the property to respondent.
Come to page number 26 and read.
Yes, my lord.
When was the property sold?
It was sold on 4/1/2022, my lord.
Even before the suit is filed?
Yes, my lord.
Your first, the injunction is not to alienate. By the time he has already alienated the property.
Yes, my lord. My lord, the main contention here is the respondent number 11 and 12, they have obtained this TI on the basis of sale deed, my lord. But the defendant who has sold the property, he does not have the right to sell the property himself.
It's a different aspect.
Yes, ma'am.
No, the first IA that you have filed is not to alienate.
Yes.
That was granted. Then he has come into picture. He
Yes.
said, I have already sold the property in the year 2022 itself.
And we filed the suit in the same year.
Your suit is of the, when was the suit filed?
In the 2022, ma'am.
There must be a date for that.
8/12/22.
8?
8th December 22.
And you sold the property on 4/1/2020.
4/11/22. It was sold to me.
You are the purchaser.
I am the purchase, 11 and 12. We were not impleaded. We got ourselves impleted by filing an application.
What is the counterclaim?
Counterclaim is a permanent injunction to restrain the plaintiff from trespassing into the property.
My lord, we are in possession of the said property, and my lord, we have been cultivating it for several years now. More than two decades, my lord, we have been cultivating in the land, and it was due to the adverse act of the defendant number 5, my lord. We are unable to enter the premises because they have obtained an injunction order.
Why the property stands in the name of Kutti Pujari? Who is he?
My lord,
Kutti
he is.
Pujari was the claimant under form number 7. He was
What is
cultivating.
the relationship of
He's the
Pujari to
son
plaintiff?
of Menu Pujarti, my lord.
Huh?
Son of Menu Pujarti. She's the sister of appellant. She's the sister of appellant.
Kutti Pujari.
Yes.
No.
He is the son of Menu Pujarti. Menu Pujarti was the sister of appellant. After
So
her
that
death.
is her sister's son is the
Yes.
plaintiff.
Yes, ma'am.
He was granted with occupancy right.
It was
He was
granted.
in possession. Once a occupancy right is granted.
Where is the question of ancestral property and partition?
My lord.
No, it is a self-acquired property. I have stated so in the written statement.
My lord, in this defendant, the Kutti Pujari obtained the grant in his name on behalf of all the other appellants, my lord. Appellant as well as the other defendants. Because he was the only educated person in the family, and considering the same fact, they.
Why that grant would contain that in the name for all the family members, this grant is given to so and so. That's your case. The grant do not disclose that this is granted in favor of Putti Pujari for the entire family.
Yes, my lord. But we were still in
That's your
possession,
case.
right?
That's your case. The fact remains is it is granted in favor of fifth defendant.
Yes, my lord. And my lord, the RTC is not yet changed in the name of the purchaser yet, my lord. It stands in the name of Putti Pujari.
What are the documents you have filed to show that you have been in possession?
My
of
lord,
property?
the sale deed.
Only the sale deed.
Title deed, a sale deed itself, because sale deed was for 21,72,000. It's shown in the sale deed, and I was put in possession. Kutti Pujari himself has filed the statement. In the written statement, he says that I have already sold the property because suit was filed on 8/12/2022. And in the
4/11/2022 is the sale
4/11/22 is the sale deed. And he says that I have sold the property to so and so, that is the respondent's hearing. And we are in possession. Still they try to trespass into the property, therefore the application came to be filed. And we have also said that the plaintiff is not a member of the family, that is on the merits of the case which need to be cited. The trial court refers to
And
that.
what is the counterclaim is?
Counterclaim for permanent injunction may not, because they are trying to interfere with the position. Plaintiff, only the plaintiff, not the other.
My lord, I would like to make a submission on this. We were in possession of the property till the interim order was passed, my lord. When the interim order was passed by the trial court, they did not see to it that whether the defendants are in possession or not. They only considered the sale deed which was produced before the court.
So to show that you are in possession of the property, what is that, what is the document you have filed?
My lord, we have only produced the photographs of the land where we were cultivating at that time. And since we were jointly cultivating, all the defendants are also cultivating in the same said property. That's why we sought
What
for.
is the extent of the property?
It is 1 acre 91 cents at a place called Nitte Village, Karkala.
Please come.
And in the written statement for Kuti Pujari at paragraph 5, he says, it is also further submitted that by having absolute right, title and interest by this dependent, my lord,
You're
finds
reading
it at
where?
page
You're reading-
41, page 41, paragraph 5,
Oh,
right hand side. It is also further submitted that by having absolute right, title and interest by this dependent,
well,
he-
41 is some,
my lord, it
41
is
is a order
annexure B1, which starts in my papers at page 39, B1, the written statement of dependent number 5, Kuti Pujari.
it's a plaint.
My lord,
36, the plaint starts.
36 is the,
37, 38 is a plaint.
yes,
For till
then,
40, it's a plaint.
and here it is page.
Annexure B1, my lord,
Annexure B1, my lord. Maybe the,
page number 44.
Page number?
44.
in that, kindly come to paragraph 5. Paragraph 5. It is also further submitted that by having absolute right, title and interest by this dependent, he had sold the plain schedule properties to Shri Arjun Kumar and Srimati Divya Arjun Kumar as per registered sale deed dated 4/11/2022. The said sale deed was took place prior to the filing of the present suit. Though the aforesaid sale deed possession of, this is what.
My lord, I would like to make a submission on this. Annexure C, my lord, page number 51. In the order sheet, it has been clearly mentioned that it is contended that plaintiff that one Menu Pujarti Timmappa Suvarna are the sisters and brothers of the plaintiff, and they have died, leaving the following plaintiffs and defendants are the legal heirs. And on behalf of them, the defendant number 5 has filed a declaration application. It has been clearly stated in the TI order which has been passed, and it is recorded by the trial court.
That order? Yeah.
My lord, the TI,
51,
TI
my lord,
order,
page number 51.
the contention of the
initial-
plaintiff is,
Let's see what is that she said.
yes, ma'am, yes.
Yes.
Page number 51, ma'am.
What is the argument? How can such an application be filed? If a grant is given, it is given to a person, individual, whatever or your understanding.
Yes, ma'am.
No, it should be a joint family property for seeking partition. How can it be a joint family property?
When it was granted, my lord, it was given in the name of one person because others were unable or incapable.
Not like that. Yes, please come. Agreed with the orders passed in 9 number 5. Invoice number 148 of 2022 dated 23rd November 2023. The plaintiff is before this court. The plaintiff had filed a suit seeking partition for the division of pay schedule properties into 3 equal pair and shares with reference to good and bad soil on the basis of the market value of the respective properties. Allot and deliver 1/3 of such share to the plaintiff. It is a case of the plaintiff that the plaintiff is scheduled properties are enjoyed by Mennu Pujardi, Timmappa Suvarna and Lalita Pujardi as they were jointly obtained the suit scheduled property under Chala hyphen GENI right under 1 Sadhu Shetty MELDOTTU, NITTE, and the said properties were in joint possession and enjoyment of the said menu of the said 3 persons. Mennu Pujardi and Timmappa Suvarna are died several years ago. And the Lalita Pujardi is the plaintiff in the above suit. And Mennu Pujardi had 5 children. They are defendant number 1, defendant number 5, defendant number 6, and defendant number 7. Among them, defendant number 5 died and defendant number 2 to 4 are the wife and children of defendant number 5. Timmappa Suvarna had 2 children. They are D8 and D9. And the wife of Timmappa Suvarna also died. It is a case that when the Land Reforms Act came into force, the 5th defendant has filed an application under Form 7 in respect of the joint tenanted properties on behalf of all the family members. And the tribunal granted occupancy rights on 25/7/1979 in the name of 5th defendant for and on behalf of the plaintiff and legal heirs. It is the case that they have been enjoying the properties jointly. The cause of action for the suit arose on last week of November 2022, when the plaintiff demanded the partition and the same is refused by the defendant. Hence, they have come up with the present suit. In that, they have initially filed an IA not to alienate, and the court had granted an order not to alienate. A written statement is filed by the said what is the name?
Putti Pujari.
Pujari, wherein he has stated that he's having absolute right, title and interest. And as the grant is in his favor by the Land Reforms Tribunal, he had sold the properties to defendant number 12 and 13.
11 and
11 and 12.
Defendant number 11 and 12 by way of a sale deed dated 4/11/2022. 4/11/2022. The suit is filed on 8/12/2022. By the time the suit is filed and an injunction is obtained, they have already sold the properties. He has already sold the properties. According to him, it is his property. And the defendants have no, according to him, the property belongs to him. And that property cannot be partitioned. Thereafter, the subsequent purchasers have filed an IA, I number 5. They've also sought a counterclaim against the plaintiff seeking injunction. IA number 5 is filed seeking an order of temporary injunction, restraining the plaintiff from trespassing into the property. It is a case of the subsequent purchasers that in the year 2022, after they have purchased the property, they have been put in possession of the property and the defendants are interfering. The plaintiff is interfering with the possession of the defendant without any manner of right and title, and hence they sought for injunction. The trial court, by order impugned, had allowed their application seeking interim injunction and also dismiss the application that is filed not to alienate, as already property is alienated. The court has observed that though it was argued by the counsel for the plaintiff that the plaintiff is in possession and enjoyment of the property by cultivating the land, throughout the plaintiff averments, the plaintiff is only urged that they are in deemed possession of the property. The court observes that by this version, it is very much clear that the documents relied upon by the defendants, number 11 and 12, prevail over the oral arguments and the documentary evidence relied upon the plaintiff. Therefore, the court has come to the conclusion that that by the date the suit is filed, property is already alienated. The plaintiff had concealed the fact of purchase of the property by the defendant number 11 and 12 and filed an application seeking a direction not to alienate. And the court has come to the conclusion that the defendant had made out a case for grant of, made out a prima facie case. And if the defendant interfere, if the plaintiff interfere with their possession, it would cause irreparable loss to the defendant, the purchaser, and it would also cause inconvenience. And accordingly, the IA filed by the defendant under IA number 5 is allowed, and the plaintiff is restrained from interfering with the property, interfering with the possession of the defendants, of a defendant number 11 and 12. Aggrieved thereby, the plaintiff is before this court. Land counsel appearing for the appellant plaintiff submits that the property was granted in favor of Putti Pujari, that is defendant number 5.
Yes.
Defendant number 5 in favor of the entire family, and he has no independent right to alienate the property. It is submitted that even though there is an order of injunction granted, the property is alienated by the defendant number 5. It is further submitted that in the light of the orders passed by the court granting injunction, and on the strength of the said order, the defendant number 11 and 12 are in fact interfering with the possession of the plaintiff. It is submitted that unless the interim injunction that's granted is vacated, it would cause a lot of hardship to the defendants, plaintiffs. And the appeal has to be allowed. Next part. Land counsel appearing for the defendant number 11 and 12 submits that the property is a exclusive absolute property of defendant number 5. It is not a joint family property. In that case, the plaintiff cannot maintain the suit itself. It is submitted that the grant, admittedly, the grant is in favor of Putti Pujari, who has sold the property in favor of 11 and 12 by taking the consideration of an amount of rupees 22 lakhs and odd.
21,72,000.
71,000.
72.
So 21,72,000. It is submitted that having taken the amount, the possession was delivered and they have been in possession of the property. It is submitted that while seeking injunction, the defendant has already made out a prima facie case and the trial court had rightly granted injunction, and no grounds are made out seeking interference with the well-considered order passed by the court. Next para. Having heard the counsels on either side, peruse the material on record. The suit is filed seeking partition in respect of the property which is granted by the Land Reforms Tribunal in respect of defendant number 5. According to the plaintiff, that property is granted to defendant number 5 by the tribunal in respect of for the whole family. As such, then all the family members have a right and title to the property, and they have filed a suit. There is no dispute about the fact that the property stands in the name of Putti Pujari, and in the revenue records also, his name is mutated. Putti Pujari himself has filed a written statement and has stated that that is his property. He is the absolute owner and he had sold it in favor of defendant number 10 and 11, 11 and 12. 11 and 12. The 11 and 12. The defendants in support of their case, 11 and 12, have filed the registered sale deed. And the written statement filed with the defendant shows that the possession is delivered to them. As far as the plaintiffs are concerned, no, except stating that it is granted for the whole family, no other document is placed. Considering the counterclaim seeking injunction that is filed by the purchasers, and while considering the application for interim injunction, court had considered the relevant aspects and rightly granted injunction, restraining the plaintiff from interfering with the counterclaim scheduled property till the disposal of the suit. And this court finds no reason to interfere as the court had considered the parameters for grant of injunction, and further the plaintiff had failed to place any documents, whereas the defendant, by placing the sale deed, and the case of the defendant number 5 had made out a prima facie case, and this court finds no reasons to interfere, accordingly dismissed. Yes, next. Call them.
Matter at 2:30, serial number 51, MB Inamdar. For appellant, Kumar MN.
Lordship appearing on behalf of respondent.
The case of payment of liquid in a running way bridge. It is a case of liquid. Molasses is a liquid which is to be weighed only in static position, not in the running.
Which on that?
Not on the running way bridge.
It's on?
The railway has got running way bridge. Railway have got running way bridges. So only liquids cannot be weighed on that. Liquids can be weighed based on the dip measurement.
Let's
That
look
has
at
not
the impugned order. Impugned order.
been-
Page number. You are appearing for Union of India.
Yes, Lordship.
Page number
What, we'll
20.
recall it order
Page
and
number
by hearing
20. Page number 20.
Hmm.
As per Exhibit 3, Railway Board Circular 12 of 2009 under Commercial Circular, so payment of molasses should be done through dip measurement. Through dip measurement. But the system came into effect only from 9 to 2009. Whereas the consignment in question was booked by applicant in the month of December 2008 and that were loaded on 3/12/2008.
So you filed a petition under section 16, seeking refund of excess charge
Yes,
on
sir.
account of excess weight and punitive charges thereof to the extent of 1,51,190
Yes, sir.
at the consignment of molasses.
Molasses. Molasses is a liquid. Like petroleum product, there are so many petroleum products, HSD, petrol, diesel, etc. So similarly, that the payment will be arrived at by dip measurement based on the density of the product. So here, this has come only trying to dip measurement, but earlier to this also dip measurement only was in existence. Even the South Central Railway, which has
This matter will
penalized.
take more time. We'll
Yes, sir.
see it on something.
Lordship, today the matter has come up before the court for recalling the order.
No. The court said the court will recall the order and hear the matter at once. Expose this matter on September 9th, not 9th, September 11th.
Much of.
Yes, please.
Serial number 22. For appellant, V. Anand.
Respondent gave that.
Yes.
The learned senior counsel was present in the video conference. The learned senior counsel was present before in the VC.
Where is he? The name of the council.
Ravi Shankar.
It's not there, I think. Look at the participants.
Not login.
Yes.
No, the suit is with respect to Order 9 Rule 13. The
We'll go ahead or again senior counsel has to.
My colleague has gone to inform him. In meantime, if he joins, he can.
The colleague is there.
He's logging in.
What is the suit for?
No, the petition, the order is with respect to Order 9 Rule 13 of CPC. The suit was for partition. An ex parte minutes which came to be decreed in the year 2000, learned senior counsel has appeared.
Yes.
Sorry, my lords.
Yes.
Lords, the suit for partition is decreed ex parte. Lords, initially the suit was dismissed for non-prosecution. Then the plaintiff filed Order 9 Rule 9 application. It was restored. Then after the restoration, a notice is said to have been issued by RPID. Lords, the contention is that this RPID was not served. And Lords, subsequently after 2 years, considering the fact that this secondary defendant had not appeared, the trial court also observes that there was a direction for affixture. So there is no proof of the fact that the affixture was affected. And there is a decree passed. The miscellaneous was filed under.
When is the suit?
Suit is of the year 1994.
Suit is of the year 1994. Initially, when he was set ex parte?
He was not placed ex parte. In 1994, the suit was filed. Note the written statement was filed on 19/9/1995.
How many defendants are there?
Lords, there are about 5 defendants, but the defendant who is contesting the proceedings is the second defendant because the heirship which is claimed by the plaintiffs is through one Kakanappa. Lords, and the second defendant set up a will that he has succeeded to this property by testamentary succession.
Yes.
This is a written statement filed in 1995 itself.
Yes.
After the written statement is filed, issues are framed. One of the issues framed is regarding the will. And thereafter, Lords, the suit being posted for evidence was not contested by the plaintiff by leading evidence, and it was dismissed for non-prosecution on 4/8/98. Lords, then they filed miscellaneous petition, and the suit was restored on 7/7/2000.
7/7/2000. Restored.
Yes. Lords, there is one fact, Lords, which I have to bring to your Lordship's notice. The counsel who was representing the second defendant in the original suit, Lords, appears to have died sometime during the year 2000 itself. One Mr. Gopinath. So there is no contest after that. Now the only question, Lords, is as to whether the service of notice effected through RPID has been done or not, and what necessitated the issuance of the second mode of service.
No, 7/7/2000, the suit is restored.
Lords, after the suit is restored, the trial court issues notice through RPID. Lords, the RPID acknowledgement has come back saying that the summons is served. The suit summons is served on the second defendant. Lords, nonetheless, after another 2 years, there is another summons which is issued through a fixture. There is no proof of the fact that the affixture was effected.
When again the suit is decreed?
Lords, the suit is again decreed on
2004.
2004.
When is this?
24/7/2004.
24/7/2004.
Yes.
When is the application filed again to restore the suit?
Notes, the miscellaneous is filed after the notice is served in FDP number 25009 of 2012.
24009 of,
25009 of 2012.
that is in the final decree proceedings.
Notes, the final decree itself is instituted in the year 2012. In that, the notice is served on 8/1/2013. 4/2/2013, the miscellaneous petition is filed.
4/2/2013.
2013. Notes, evidence has been adduced. Notes, if your lordships were to call for the TCR or otherwise permit us to place all the evidence on record. Notes,
No,
because
where,
matter.
where is this? Where is the parties are residing? Let's look at the cause item. Of the
Notes,
suit.
parties are residing at different places. Notes.
That's what we'll just see.
Because the plaintiffs are residing at Krishnarajpuram and the second defendant Notes is residing in Indranagar. This is a residential property where the present defendant is residing.
This appeal is filed by Krishna Reddy.
Please.
Let's just go to the cause title and before the trial court, in the
Trial court,
miscellaneous
no?
petition.
Notes, page number 14, 14.
3rd Street, Krishnarajapuram, Bangalore. The
Krishnarajpuram.
respondents are staying where?
Notes, they are staying in Indranagar.
In all of them are staying in Bangalore.
Notes, they
And what
are
is
in
the
Bangalore, they are in
relationship?
Indranagar.
What is the relationship between the parties?
Notes, sister and brother, Notes.
Sister.
Narayanamma is the sister of Krishna Reddy, that is A.K. Reddy. Notes, the uncle had died without issues. That is Kakanappa. Uncle, essentially the paternal uncle, died without issues, and it is his share which is being sought for as the class 2 heirs by the plaintiff. But Kakanappa has executed a will which is dated 26/8/1987. One opportunity, my lords, because if I am in a position to demonstrate that bona fides are there for non-appearance.
1994 suit.
I bow down to what your lordship said, my lords, but this is a case
We are where 40 years.
My lords, 1995.
40 years almost.
My lords, I just want to say this, my lords. There is a will which is propounded to be proved by filing a written statement in 95.
In such a close relation, if somebody says that about passing of a decree and about till the final decree.
Lords, I also need to, Lords, I fully bow down to what your lordship said, but I also need to bring it to your lordship's notice, my lords, that in respect of other properties, there were other litigations which were pending. My lords, what happened? There were 2 other members of the family who had died without issues. The heirship was being claimed. These proceedings are still pending up to the year 2012. That is essentially from the year 2004 to 2012. The passing of this decree was never disclosed. Because there also, my lords, similar plea has already been raised. Lords, the conspicuous silence for these years between 2004 to 2012 is what your lordships may have to consider, my lords. Lords, because valuable rights in respect
I'm not
of...
able to understand. 7/7/2000 suit was restored.
Yes, my lords.
What is this notice summons that I'm not able to understand?
Lords, after the suit is restored and the suit is to be considered afresh, Lords, then the court notice is issued for appearance of the parties.
And you have filed the suit. You are not a defendant in the suit.
Lords, I am the
You have filed the
defendant.
suit for partition.
No, I am the defendant. I am the second defendant in the suit.
No, please come to.
Lords, I am the second
OS
defendant.
number double on this cause title.
Lords, please, my lords.
That is in the FDP. Where is this?
Lords, no, miscellaneous. This is in the miscellaneous, my lords. If your lordships were to take the miscellaneous, because what all documents are produced is pertaining to miscellaneous, my lords.
Give those papers.
Page number 217 is the judgment passed. Page number 217, my lords, volume 2.
Volume?
2, page number 217. Lords, your lordships will find here Narayanamma is staying in Indranagar. The address given while service of notice was effected in the original suit is in Hoskote town, whereas we are residing in Kyarpuram. Veeraswamy is the first defendant. Krishna Reddy is the second defendant.
He is staying at Krishnarajapuram, Bangalore.
He is staying at Krishnarajapuram, Bangalore. Lords, and if your lordships were to see me, lords, at page number 222. These were the issues framed, lords, before the dismissal of the suit for non-prosecution.
400 and?
222. Lords, internal page 6 of the judgment. Issue number 4, my lords.
No, that application filed in 2013 was heard by
Lords,
the court when?
Lords, this is heard by the court after a due inquiry and disposed of by the order impugned in the year 2024.
A 2013 application.
Lordships, my lords, what happened? The trial court had clubbed this matter along with the final decree proceedings. And miscellaneous proceedings was not being conducted, but final decree proceedings was being conducted. Lords, it is in such circumstances we find a writ petition before this honorable court. This honorable court, taking note of the fact that the miscellaneous is pending, directed that the miscellaneous should be disposed of within 30 days. Until such time, the final decree should not be drawn. It is in the light of the directions issued in WP number 2526 of 23 that the matter was taken up and the miscellaneous proceedings was concluded.
No, please come.
Otherwise,
please.
but impute order is at page 14.
Page number?
14, my lords. Lords, may I make this request, my lords? Because I had some matters in Dharwad, I had to come for VC. The network was very bad in the kiosk in the Karnataka. Can I request, my lords, if your lords can take it up on Tuesday or Wednesday, my lords? I will come for physical hearing. Matter may require, my lords. My apologies, my lords.
At the request of one counsel, the petitioner pose this matter on Tuesday.
Lordships.
Wednesday.
Please. Wednesday, please.
Yes.
Tell number.
Yes.
23. Cell number 23.
I beg to appear for respondent, madam.
But I appear for the appellant. Suit for specific performance. Injunction application has been allowed. I appear for defendant number 5 in this suit. May I just request your lordship kindly take the plaint, my lords, at page number 20.
Is there online?
Let's page 28, my lords, is a plaint. My lords, may I kindly see, my lords, Gulappa, defendant number 1. My lord, suit was filed against a dead person, and pursuant to filing of the suit and the summons was served, they have in fact filed a memo stating that defendants 2 and 3 are the legal representatives of defendant number 1. My lords, the entire case, my lords, of the plaintiffs are, could your lordship kindly turn out to the page at page 29, my lords. The paragraph 4, my lords. I'm sorry, can I read from para 3, my lords?
Yes.
Lords, plaintiff submits that the originally, the land bearing survey number 47/2, measuring so-and-so, situated so-and-so, was belonging to Venkatappa, who is none other than the father of the first defendant and grandfather of defendants 2 and 3, and got it divided among his children, and same was allotted in favor of Sri Gulappa, the first defendant herein, under a partition dated 5/8/1965. After the partition, the first defendant Gulappa and his son have executed a general power of attorney dated 28/6/2011 in respect of the said property.
He is saying that again, all the children also have executed.
My lords, this agreement, my lords, according to which they have placed the suit, is not executed by defendants 1 and 2, 1 to 3. My lords, the entire case of the plaintiffs is that fourth defendant is a power of attorney holder of defendants 1 to 3, and fourth defendant has executed this agreement. For this, my lords, may I just read para 4, my lords. The plaintiff submits that the fourth defendant had got the land under a general GPA, and after he has agreed to sell the land bearing survey number so-and-so in favor of the plaintiff, which is more fully described in the schedule. Plaintiff submits that the fourth defendant is having intention to sell. Kindly note, my lords, it is the fourth defendant who has an intention to sell the suit schedule property for his
domestic and other legal necessities. My lords, defendants 1 to 3 or the landowners, my lords, or the owners of the property have not executed any agreement. Your lordship kindly note, my lords, 28/6/2011 is a general power of attorney according to them.
Basing on the general power of attorney executed by D4 on behalf of defendant
That is the,
number 1, 2,
that
3,
may be the
there,
pleadings. That may be the pleadings. If your lordship may kindly permit me to pass on the documents, my lords, under which he relied upon before that.
You have given him a copy of.
Well, let's see, he is the plaintiff, my lords, and it is his documents. I am not relying upon any documents.
Yes.
Could my lords kindly take page 13, my lords? Page 13, my lords, is the general power of attorney dated 28/6/2011. And my lords, I'm not going to show you, my lords, all other clauses of this document, but for the fact of just looking at the agreement, the date of the general power of attorney.
Dated?
Kindly, my lords, it's 2011, my lords, it's 28/6/2011.
2011.
Then, my lords, we have the agreement at page 21.
Agreement at?
Page 21, my lords.
Oh.
It is dated, my lords, 25/2/2021. 25/2/21.
When that Gullappa died?
Gullappa, my lords, died on 29/3/2016.
29/3/2016.
Yes, ma'am, much before the agreement. My lords, irrespective of that, kindly take, my lords, page 23. It is this plain paragraph 3, my lords. Now, this agreement to sell witnesseth that in pursuance to the above said sale consideration, the purchaser has paid an advance of rupees 5 lakhs and the manner in which they have paid, they have given. My lords gets A, B, C, D, E, F. Kindly see, my lords, the consideration, advance consideration is alleged to have been paid on 23/9/2002.
23/9?
2002. My lords, now all that needs to be considered is, my lords.
No. For a amount that is paid on 23/9/2002, agreement is on 29/3/2016.
It could not be, my lords, for the fact.
No, that is what they say. 29/3/2016 is the agreement.
My lords, the agreement is 25/2/2016, 2021, my lords.
No, 1 minute. Agreement of sale is
25/2/2021. 25/2/2021.
Is the agreement of sale.
Correct, my lords.
Now,
my lords, payment according to them.
Now, GPA is on 28/6/2011.
11. So, my lords, if suppose certain.
What is this on 29/3/2016? That's the date of death.
Correct, my lords. Then, my lords, advance sale considerations is supposed to have been paid on 23/9/2002. On the date, my lords, when he pays advance.
Where do you get that?
My lords, page 23, my lords. Of this is the agreement.
So.
There are 5 payments according.
9/2002, 23/9/2002, or not 23/9/2002.
Correct, my lords. On the date, my lords, of these payments, even suppose agreeing that these payments were made, defendant number 4, who's my power of attorney holder, alleged to be my power of attorney holder, had no power of attorney on the date of 2002. The power of attorney is only in 2011. Then, my lords, the defense taken by defendant number 4, that is the alleged power of attorney holder of my.
Let's see his plaint. Again, come back to the plaint.
Plaint, my lords, may kindly take page 30, my lords. Paragraph 5.
Yes.
Plaintiff submits that the 4th defendant is having intention to sell the scheduled property for his domestic and legal necessities. Hence, he has entered into an agreement to sell on 25/2/2021 and fixed a total sale consideration at 30 lakhs and received rupees 5 lakhs as advance sale consideration amount. And
What is the GPA that is given?
Well, it's now according to them, according to the plaintiff, I have executed a GPA in the year 2011. I agreed to sell this property in favor of 4th defendant is what the covenants of the general power of attorney states. Now, my lords, that agreement, that general power of attorney is not only disputed by defendants 2 and 3.
Is it a registered general power of attorney?
No, my lords, it is not. It is not. My lords, all that, my lords, my humble submission is we need to consider 3 dates. Payments according to them is paid in 2002. 2002, my lords, I had not given him any power of attorney. Then, my lords, 2011 is the general power of attorney.
Yes.
2016, my lords, is the date on which the agreement is entered in. I mean, so 2021 is the date of agreement is entered into. Gullappa, my lords, dies in 2016. On the date of death of Gullappa, my lords, even suppose, presuming the power of attorney was there, it would also get extinguished, my lords.
Yes.
My lords, these aspects, my lords, though was pleaded before the trial court, the trial court, my lords, does not consider these aspects and passes an order of restraint. My lords may kindly have page 15, my lords.
Where is the discussion of what you have said in this?
My lords, kindly see page 15, my lords. There is absolutely no discussion at all, my lords, about
That's
these
what, there
dates.
is no discussion
There's
on that.
absolutely no discussion. That is why, my lords, I'm in an appeal. Prima facie case has never been considered. These documents, these payments, the death of Gullappa has not been considered at all. My lords, kindly see page 15, my lords. What the trial court says is that,
I've read that.
correct. That is all it is said. My lords, if there is any transaction between fourth defendant and the plaintiff, how am I, my lords, my property subject of this? It is absolutely.
What do you say? Yes, Mr. Counsel.
Please, my lord. In this case, my lord, GPO holder who has purchased the land, my lord, subsequently, my lord, continuously having possession. He has shown
How
me
he has
the
purchased the
document.
property?
Property to,
Let's look at the GPA.
please, my lord.
This is not a registered GPA.
No, not registered.
Then how the rights in
Then,
immovable
because my
property
lord,
will
he
be
has
transferred?
shown me, my lord, I got the, because they are adjacent owners, my lord. The Bonaram is not a different person. He
Why
is
did you
also
give-
residing in the
No,
same
you have
village.
given the money in the year 2002.
My humble request, my lord, because he is having a property. Therefore, he has got it executed this agreement of sale. Whatever amount he has received, the GP order, I am having this property, you purchase it. I have paid 5 lakhs, my lord. That 5 lakhs he has paid to me. But does not mean that I have not paid money to them. But agreement was executed when I have started to demand the money. And whatever money, whether he has paid to them or not, that is the question to be decided by the trial court. Now, my humble request, my lord, what happened now subsequently? He is also, my lord, purchased the property from this bit of land, that GP order, from them only, and got it partition, my lord, allotted in favor of fifth defendant. So therefore, I have sought for not to alienate. It is a equitable relief has been granted. That does not mean that they have not selling the property, because the fifth defendant is also got it allotted, purchased the property from defendant number 2 and 3.
Yes.
While allotting the property. Therefore, when the partition was took place pertaining to the agreement of property, my lord, therefore I have come before the court for specific purpose.
Yes.
Now, he is saying that his statement is also recorded. There are transactions admitted by the fourth defendant relating to this property is also made transaction, my lord, on behalf of this defendant. Now, fifth defendant coming before this honorable court saying that I am nothing to do with, because got it partition recently on 23, my lord, during 2023. Now, my lord, now tomorrow they may alienate or create the property. The against all the defendants, it is affected. Not only the GP order, but also the other parties.
Yes. Please.
It is equitable relief, my lord. Nothing is going to be happen to the plaintiff, defendant. Fact to be decided before the trial court, my lord.
Agreed with the orders passed in I number 1, invoice number 1048 of 2024, dated 16th July 2024. The defendant number,
Defendant number 5, Honnappa, was not a party to the agreement at all.
who is he? What is the relation?
Let's see, he's the brother of defendant number 1. And in the agreement, my lord,
The
she's-
defendant number 5 is before this court. It is the plaintiff, the respondent herein, the plaintiff had filed a suit for specific performance of an agreement of sale dated 25/2/2021. It is the case of the plaintiff that the defendant number 1, the father, 2 and 3, the sons, have executed a GPA in favor of the 4th defendant by dated 28/6/2011. The 4th defendant in turn has executed an agreement of sale in favor of the plaintiff on 25/2/2021. And after receiving the earnest money of an amount of rupees 5 lakhs, when the defendant had failed to execute the sale deed, that made the plaintiff to come before the court seeking specific performance of the agreement of sale. In that, he had filed an application, that is I number 1, seeking injunction restraining the defendants from alienating the property. The same was opposed by the defendants. Then counsel opposed by the defendants. The trial court, while granting injunction, had observed that the defendant number 4 has admitted that there was a financial transaction between himself and the plaintiff regarding loan of rupees 5 lakh, and he has repaid the same. The defendant number 4 has not produced any document, and he has not stated anything regarding mode of alleged repayment of amount. The court has also observed that on perusal of the documents produced by the plaintiff, the defendant number 4 is also having 1 acre of land in survey number 47/4 of Pulima village. Hence, it was not necessary for the plaintiff to create documents to grab the land as alleged by the defendants, and it is also not necessary to create GPA. The court felt that if the injunction is not granted and the suit scheduled property is alienated, then it would lead to a multiplicity of proceedings. It's a basic principle of law. The suit scheduled property is to be preserved till disposal of the suit. In those circumstances, the court had granted an injunction restraining the defendants from interfering with the and from alienating the suit scheduled property. Next paragraph. Aggrieved thereby, the defendant number 5 is before this court. It is the case of the defendant number 5, the appellant before this court, that it's a joint family property.
No, my lords, there is a partition in 1965, which is pleaded in the plaint itself, my lords.
That there is a partition among the family members, that is defendant number 1, 2, 3, and 5.
Defendant 1 and 5, my lords. And
1
his
and
brother.
5, defendant
his
number,
brothers.
you are brother of defendant number 1.
Correct.
Defendant number 1 and 5, and the suit scheduled property in the partition fell to the share of defendant number 5.
No, I am very sorry, my lord. 2023, my lord, partition was took place. I have placed the document because RTCs
And
are
this is
available.
page 29, my lord.
Page number?
Recently affected,
29,
my lord.
paragraph 3. I'm showing the
Page
plaint.
number 20,
As per
29,
plaint
para
government, my
3.
lord.
para 3.
My lords, from 6 lines from the bottom. First defendant and grandfather of defendants 2 and 3.
Yes, yes. And,
8 to 23, my
even
lord.
as per the plaint averments also.
8
there
to
is a
23, my lord.
partition deed of the year 5/8/1965.
Subsequently,
And
my
after
lord,
the
this property, para number 10, my lord. Because
In the-
8 to 23, it is available in the revenue record, my lord. Otherwise, I can't mention
I
this
am
date.
looking at your plaint and dictating this
Yes,
order.
another, the partition, not only this property, my lord, several properties are available. Again, they have got it partition on 8 to 23,
So
my
that
lord.
we are not going into, that 2022 partition. I'm dictating the facts from the plaint.
Please, my lord, please.
that even
again,
as per the plaint also. After that, the GPA is executed in favor of the defendant on 28/6/2011. Then counsel submits that the plaintiff had filed the agreement of sale, the GPA and other documents before the trial court, and the same are placed before the court. He submits that the general power of attorney is dated 28/6/2011, which is a unregistered general power of attorney. And the agreement of sale is on 23/9
25 to 2021.
25/2/2021. He has drawn the attention of the court to the agreement of sale. In the agreement of sale, it is the case that an amount of rupees 5 lakhs has been paid to the fourth defendant on several dates. That is 23/9/2002. 5 lakhs is paid on 5 different dates
Same day, my lord.
on the same day by way of
By way of checks,
by way of checks on 23/9/2002. When counsel for the defendant submits that, fifth defendant appellant submits that, the day when the defendant had taken, when the fourth defendant had taken money from the plaintiff, there was no GPA that is executed by the first, second, and third defendants in favor of the fourth defendant. When the money was taken in the year 2002, an agreement of sale is executed on 25/2/2021. If looking at the dates on which the amount is paid by the plaintiff to D4 and the dates on which and the agreement of the GPA, the agreement of sale, and the contents of it clearly discloses that as on the date when the amount were received, there was no agreement of sale. He submits that. And what is the other contention you are raising?
My lords, the other contention, my lords, is that fourth defendant, even assuming that he is a power of attorney holder, in 2002, he had no authority.
That's what I already recorded.
I'm
that.
sorry, my lord.
It is submitted that the property as per the partition fell to the share of fifth defendant without even making him a party to the suit proceedings.
Agreements, to the agreement.
He was not a party to the agreement. Suit, they have made you a party. Without making him as he was not a party to the said agreement, that is not binding on the fifth defendant. It is submitted that the first defendant died when?
My lords, he died on 29/3/2016.
He has, the first defendant died on
29/3/2016.
29/3/2016. And after the death of the principal, the present agreement is entered into by the fourth defendant in favor of the plaintiff. It is submitted that all these dates and the events that have taken place clearly reveals that there is no prima facie case in favor of the plaintiff. Just because the fourth defendant has taken money from the plaintiff, that itself cannot be a ground for granting injunction. It is submitted that as he has failed to make out a prima facie case, the trial court ought to have not granted injunction in favor of the in favor of the plaintiff, restraining the defendants from alienating the property. Next para. Then counsel appearing for the respondent plaintiff submits that there is no dispute about the fact that the plaintiff had paid an amount of rupees 5 lakhs and to the fourth defendant. And when the fourth defendant had failed to execute the sale deed, he was constrained to file the suit. Considering all these aspects, the court had rightly granted injunction, restraining them from alienating the property. If such an order is granted, the purpose of filing the suit itself will be frustrated, and unnecessarily it will give rise to the multiplicity of proceeding. It is submitted that the amounts that are given by the plaintiff are by way of checks, and which clearly shows that the money is given by the plaintiff to the defendant, and the court had rightly granted injunction. Next. Having heard the learned counsels on either side, peruse the material on record. This is a suit for specific performance of an agreement of sale dated 25/2/2021. As per the agreement of sale, the amounts are received by the D4 in the year 2003. 2002. On the same day, by way of different checks, he has received an amount of rupees 5 lakhs. As on that day, the defendant 1, 2, 3 have not executed the alleged GPA that is dated 28/6/2011. The first defendant had died in the year 2016. Now, the fifth defendant, who is as per the partition, he has also right in the said property. He was not a party to the GPA.
And the agreement. And also.
A party to the GPA and to the agreement of sale. No, because nobody is a party. GPA holders are all GPA. They are not a parties to the GPA. When that is the case, just because a fourth defendant had taken the money from the first plaintiff, that the court cannot consider it as a prima facie case. The property belongs to the plaintiff. The property belongs to defendants 1 to 3 and 5. The 1 to 3, the GPA is also it is a unregistered GPA, and by virtue of that, he has entered into an agreement of sale. That too after the death of the first defendant, and the fifth defendant is not a party to it. In those circumstances and in those factual backdrop, the court cannot conclude that the court ought not to have given a finding that there is a prima facie case in favor of the plaintiff. When all these contentions are raised by the defendant, the court ought to have discussed the same in detail in the order. But the court had failed to discuss any of these facts, nor there is any finding on that ground. And in the considered opinion of this court, the plaintiff had failed to make out a prima facie case for granting such a relief of not to alienate, and accordingly, the appeal is allowed in the order impugned before this court is set aside.
Well, request, my lord. Only fifth respondent's appeal, my lord. In respect of fifth respondent property only, my lord.
That is only one property.
Yes, only because the injunction
The whole
order
property is
granted
one and
against
only
all the
One property
defendants.
is there, madam.
Yes.
Only in respect of fifth respondent, my lord.
Yes.
No, because injunction order, my lord, remaining against the other defendants.
None.
Cell
That
number
can't be, yes,
24,
24,
Rudrappa P.
RPFC of 2021.
My lord,
Was this matter on
28.
3rd of September? Yes, 25.
short date may be given, my lord. Short date may be given, 24, my lord, short date may be given, my lord.
What is that? Short adjournment you want?
Short date,
Uh,
this month, my lord, any date,
22nd.
obliged.
Next 25.
But 25,
petition.
Hmm.
Any date, please.
2022. Then we'll have on 3rd September.
cell number 26,
In all these cases, there is an interim order, is continued. If there is not, yes,
In serial number 25, I sought for stay, madam, because there was an order of attachment of salary.
no. 25, now it can't be granted.
26,
We'll hear it.
Petitioner in this case, 26 serial.
20?
Said Khalil Pasha.
Petitioner.
Appear for respondent in this case, 26, my lord.
Yes. You are for the respondent.
Please, my lord, please.
Who appears for the
In
petitioner?
this case, I am affair with the petitioner.
Hmm.
At least refer to mediation, my lord. Chance.
He's saying that it can be referred to the mediation.
My lord, I have no instruction.
to
I
lead
I
the live
will take
file.
instruction and submit to
Let
lordship.
it be
also
there,
present is for the
let it be
petitioner
there in
present
the
is-
list, get instructions.
Please, my lord.
It will be there in the list tomorrow also. 26. Next 27,
Till number
petitioner,
27.
my lord. My lord, short date may be lord, third occasion.
interim order is granted in this.
Granted, my lord.
Huh?
Yes, interim order is already.
And
granted.
then no urgency for a 24 matter, post this matter on September 24th.
Till number
Yes.
28, urgent, 29. 29. Party in person, Sangeeta Reddy.
Post this matter on 4th of September. Yes,
For 30. 30 urgent, 31.
Petitioner. I have
Vasanta
complaint
VR.
appearing for the petitioner. I have served the hand summons to the council before the trial court, my lord. And I
interim
have
order is there,
deposited the amount.
interim order is there
Yes,
in
my
your
lord.
favor.
Yes, my lord.
Post this matter on 17th of September.
Till number 32.
For the petitioner in
Govind
this case,
Raj.
Your Lordship, I may kindly request for the matter to be taken up on 26th, the 22nd, subject to the discretion of the court.
For the
Yes.
response.
22nd,
Much obliged, Your Lordship.
Till number 33.
The petitioner, my lord.
For the
They go.
respondent in
The
this
interim order in my
matter.
favor, my lord, in this matter.
you have an interim order, 2024 FC. Yes.
So you may request for 22nd itself, Your Lordship, and for the respondent in this matter.
What
subject
is
to
the matter about? Maintenance.
Maintenance.
Interim order is granted.
Interim order of stays granted, I am for the wife.
There must be on some condition.
Please, my lord.
You complaint with the
I've
Post this matter on September 23rd.
Please.
Yes.
Till number 34 disposed, 35.
present to the
Ramesh K.
petition lordship, any date in the last
Awaiting
week of
service of notice.
this month.
Avoid service of notice in respect of respondent.
We have already served it.
36.
We have given
For the
it.
respondent.
You are appearing. Huh?
Okay,
35.
35. What do you want?
Already given a copy.
After service.
Who is appearing? The name is not there. For the respondent, who is appearing?
So
Counsel.
we have already served. We have waited for the report.
That memo is not.
Once we get the reports, we will. So we are wait for the reports. Once we receive the report, we'll.
Post this matter
22nd.
on 3rd of September.
Till number 36. The respondent. Nanjunda Swami N. Manmohan P N.
Yes. Post this matter on 2nd September. Yes, 37.
37.
Petitioner, my lord.
Yes.
I for the petitioner. Notices of the.
Interim order is there.
Interim order.
You're insisting for an interim order.
No, I have sought for, I challenge the order passed by the trial court, interim maintenance. So I have sought
Oh,
for
it has to be
enhancement.
heard finally.
Yes.
2024 matter that will come on September 23rd. Yes.
Till number 38.
For petitioner in this. matter.
Krishnamurthy.
Yes.
Petitioner in this matter.
Yes, yes.
We filed a dispensation memo, my lord,
Hmm.
against respond number 2 to 7.
Memo for dispensation of notice to R2 to R17.
R7.
One is,
One is with issue.
one is served.
We
This may be
we
under
relieve
non-notice.
sought against respond number 1, my lord.
No. You want a dispensation of notice to 2 to
2 to
17.
17,
One is served or not?
no, my lord.
A memo is filed, seeking dispensation of notice to R2 to R17. Memo is taken on file and the notice is dispensed with at the risk of appellant. Issue notice to respondent number 1, post after service of notice. Next 39.
Till number 39.
For petitioner, my lord, there is a officer raising an objection on maintainability. This appeal is filed in against a regular appeal. Kindly permit me to convert into miscellaneous appeal into regular appeal.
MMP is filed. Seeking to withdraw the writ petition.
Conversion into regular appeal, madam.
A memo is filed that the office, no, not memo, the office has raised an objection onto the maintainability of the appeal. A memo is filed stating that permission, they sought for a permission to convert this appeal into a regular appeal.
Regular appeal.
Regular appeal accordingly. The permission liberty as sought for is granted.
Disposed.
Yes, next.
40 to 43, 42 disposed, 43.
Mm. You have an interim order? First time it's coming. Let it be there in the list 43.
43.
Yes.
2 months.
44,
44,
I appear for petitioner, my lord.
Hmm.
44.
on whom you have taken
acceptance of notice.
Respondent.
this court by order dated so and so has directed the party to take out notice. Hmm. As per the order passed for this court, the appellant had petitioner had taken out pay of publication and filed a memo for acceptance accordingly. So the said memo is accepted and notice to so and so is held sufficient.
Then
Interim
number
order may be. Interim order.
Huh?
Interim order may be.
Look at it, if interim order is read, extended till the next date of hearing. It's 45.
45,
But we appear for the petitioner in this case, kindly place for a week's accommodation. This is the matter pertaining to legal service committee, my lord. We have filed the NOC vakaat and we have received the file, my lord. There are two minor objections, my lord. We will comply it in another 2 days.
Once the orders, office objections are complied with, post this matter before the court.
till number 46,
Yes.
petitioner Suyo Kerala,
We'll file the memo in the short time, your lordship. There was
What
some-
memo?
of having served to the trial court counsel, your lordship.
Punishing of so and so PPF. Memo for
Served
having
a
taken
copy
out
of the
notice on the council appearing before the trial court.
We've served a
For
copy.
filing a memo as per the order of the court, post this matter on 3rd September. Next 47.
number
I am appear
47,
for respondent, Your Honor. They have to file affidavit. Their counsel are not at present. Last time also you want.
Here you appearing, where is your
I'm not able to
counsel?
reach him today because they don't know.
But he has to, this is a high court, parties can't appear like
My
this.
lord, the affidavit has already been filed and a copy has been served also.
No, not yet, not served.
It has been-
Till now, not yet
it
served
has
any
been
copy.
filed.
And their counsel at all not yet come here court also. You also warned last time, Your Honor.
Has been filed, my lord.
Post this matter after 2 weeks.
till number 48,
For the petitioner,
Yeah.
Lordship, I have an interim order in my favor. I have
Hmm.
complied with the conditions of.
Receiving of copy of hand summons
And it comes out the copy of the.
by petition to take out notice on the council correspondent.
and then
Yes, post this matter.
My lord, can,
21st of August. Yes, next.
till number 40,
50,
59 urgent,
50 and 51.
50
both.
was already 11.
50?
One is.
On 50 and 50.1. Post these matters on 14th of October.
Your ladyship, with the leave of the court. There was confusion regarding serial number 33. No conditions have been imposed while granting an interim order, your ladyship. It was an interim order of maintenance of rupees 7,500 granted.
So-
A sum of 1 lakh was deposited without prejudice, my lord, which I made a submission. So lodged in view of the deposit, there'll be a stay, my lord. And she's earning 1 lakh.
Is the
33. There's no such thing
33
recorded in the
post-
order. I was also directed to serve. a
on
copy.
27th of August.
Much obliged, your ladyship.
your permission, the court.
I said your advocate should be present. Please ask your advocate to be there before the court.
My lord, can you give me a short date, please? 5 years I'm fighting this case for my child. The
Then-
longer it's taking, the distance between father and child is becoming more, Your Honor, please. 5 years I've been kept away from my
Are
child.
you want to argue as party in person?
I
Or
would,
you
I
have
would love to, ma'am, but I'll make mistakes. That's why I'm not doing it, ma'am.
Then let your
Ma'am, I think
advocate
give me
be
short
there.
date, ma'am. 5 years I'm fighting like this case for my child, my lord. 5 years.
Then advocate is on record.
No, I'm not able to reach him, my lord. Give me a Friday date, my lord, please. They don't let me talk to my child. They don't let me meet my child. And my lord, this photos. are-
Post this matter on 27th.
Thank you, my lord. Thank you.
And make sure that no party appears before the court.
I'm sorry.
No, like there should be a, on the cause list, there should be a direction. Party shouldn't, unless and until the court wants, party should not appear in the court, nor they should submit, make any submissions before the court.
I'm sorry, ma'am. I'm sorry, ma'am.
Madam, 44 date.
27 August.
Thank you.
ಅಲ್ಲ ಇವರೇ ನೀವು ಬರೀ ಅಡ್ಜೆಂಟ್